Please, my lord. My lord,
Yes.
sir, the urgent matter, my lord, eviction matter, my lord. Yesterday only I came to know, my lord, that tomorrow that eviction process will be carried out, my lord. That too, my lord, I came to know through a letter written by the Deputy Commissioner to the Superintendent of Police, my lord, seeking the deployment of the force, my lord. No notice, my lord, nothing, my lord. They are proposing to evict my home, all the residents by tomorrow, my lord. The urgency is there, my lord. So I request, my lord, humbly pray, my lord, to my lord.
Have you filed the writ petition?
My lord, it's on the process itself, my lord.
Ah.
By it will be filed, my lord. Much obliged.
May I please, Lordship?
Yes.
My lord, I beg to mention item 12 of today's list, my lord. I would like to,
Please speak on the microphone, please.
item 12 of this today's list, my lord.
Yes.
I would like to file IA in this writ petition, contempt petition for implement of necessary party, my lord.
You are the petitioner.
Yes, my lord.
How much
So,
time?
4 weeks time may be given, my
All
lord.
right, as paid for by the learned counsel for the petitioner. 4 weeks time is granted. Now the matter stands adjourned for 4 weeks. To enable him to file an application for implement of necessary party. Yes,
May I please, Lordship? Lordship, I beg to mention item number 18, Lordship. Lordship, the
11,
18, Lordship.
sorry,
1/8,
1/8.
Lordship.
Yes,
May be listed after 2 weeks, Lordship. A. Ahmad, Lordship, leading counsel for the petitioner. He was about to come from Guwahati, Lordship, but due to some personal issue, Lordship, he could not
as
come.
paid for on behalf of the petitioner, the matter stands adjourned for 2 weeks. Yes,
Deeply please, Lordship.
My lordship, I beg to mention item number 14, 15, and 16, your lordship, on behalf of leading counsel BP Chair. Matter may be listed after 2 weeks, your lordship.
why do you want adjournment?
He is out of station.
All right, on the prayer made on behalf of Mr. B.P. Chal, learned counsel for the petitioner, matter stands adjourned for 2 weeks.
Obliged.
14, 15, 16, huh? Same order. Yes,
May I, Lordship, I beg to mention item number 17.
yes.
Lordship, I may be allowed to withdraw as the matter become infectious.
How?
It has been complied.
All right. Your name?
B type of
Mr. B. Typodia, learned counsel for the petitioner, submits that the order of this court has been complied with. And therefore, the petitioner has no reason to press the contempt petition. Stop. Next para, in view of above, the contempt petition stands closed.
Obliged.
Lordship, I beg to mention item number 11,
Yes.
on behalf of Mr. D. Pang, my lord.
Hmm.
Mr. D. Pang is out of station, my lord. So matter may be listed after 2 weeks, my lord.
All right. On the prayer made on behalf of Mr. D. Pangan, learned counsel for the petitioners, the matter stands adjourned for 2 weeks.
Obliged, my lord.
Yes, my lord, this matter was taken up on Friday, I think, my lord, regarding the transfer matter, my lord. And standing counsel was supposed to take instruction from the secretary as to how that order was passed.
What instructions was required to be taken?
Regarding that passing of that impugn order, my lord.
Can you just
Yes, my lord. Yes. Yes, my lord.
recapitulate what we had discussed the other day?
Yes, my lord. My lord, may I turn to page 20, my lord.
Yes.
I'm challenging this order, my lord. This is the impugn transfer order, my lord. Whereby, my lord,
You are Tana Totu.
yes, my lord.
Tana Totu is the petitioner.
Yes, my lord.
It transferred from Lemi Pekaka Singh to East Kamen.
Is
Sepa.
coming. Yes, my lord.
Why are you agreed with this order?
No, my lord, before going into the merits of the case, my lord, my lord, may kindly turn to the next page, my lord.
Yes.
which is 23 February 2021, my lord.
Mm.
This is the date on which I joined, my lord.
You joined?
On the 23 February 2021, my lord.
Where did you join?
At Lemhi, my lord.
Lemhi.
Yes, my lord.
Okay. Then.
Now, my lord, when I was peacefully serving here, my lord,
Mm.
to my utmost effort, my lord,
Mm.
a UO note was initiated, my lord, by the MLA come president of the Arunachal Pradesh BJP party, my lord,
Mm.
which my lord will find at page 27.
28 is the type copy.
Yes, 28 is the type copy, my lord.
Mm.
Now here, my lord, the MLA has sent a UO note requesting the Minister Land Management to transfer the private respondent, number 4,
Mm.
to Lemhi, my lord. My lord will find the date down below. I'm sorry, my lord, on the last occasion also I could not, it has not been reflected in the tablet copy, but my lord will find in the
It's
original
24
copy.
copy.
Yes,
24.
yes, my
All
lord.
right.
Yes. Now, pursuant to my lord,
See, one thing, Mr. Counsel, what is the transfer policy? You can be in one place for 2 years,
my lord, my
correct?
lord.
So you were transferred into Lemhi
Yes,
in the year 2021.
yes, my lord.
So by this 2023, you had completed 2 years.
Yes, my lord. I'm not agree with that, my lord. I'm aware, my lord, that transfer and posting are incidents of the service, my lord.
Yes.
But I'm agree with the manner in which I was transferred, my lord. Now, the UO note clearly says that, my lord, the private respondent has to be posted, my lord.
Okay.
That is why I agree with, my lord. And my lord, I turn to page 37.
$37. Yes.
37 is the order by which the private respondent
Mm.
was transferred to Lemhi, ma'am.
Okay. Pursuant to this UO,
Yes,
This-
my lord.
this
Yeah, pursuant to
order-
the UO note, my lord.
this order came.
Yes. Which is, my lord, 31st May 2023.
May.
Yes.
Yes.
And my lord, we kindly see, my lord, the private respondent is an assistant survey and settlement officer. He's not even a regular DRSO, my lord.
Mm.
He's junior to me, my lord. My Peter Force, my lord.
Mm.
And in the remarks, my lord, they are allowed to look after the DRSO charge of their respective district until further orders, my lord.
Huh.
Now, despite this order being passed, my lord, whereby the private respondent has been transferred to the place where I've been posted, my lord, I was not posted out, my lord. This order was passed, my lord, on 31st May 2023, my lord. But after more than 2 months, my lord, one fine day, my lord, the impugned transfer order is passed, my lord. Whereby, my lord, I'm transferred out from Lemhi to SEPA, my lord.
Yes.
Therefore, my lord, I'm alleging malafide, my lord, on part of the state respondents, my lord. Whereby only on the insistence of the MLA and the UO note, my lord, this impugned transfer order has been passed, my lord. And in the UO note also, it has been specifically mentioned that the private respondent has to be posted in place of me, my lord. Despite the fact that, my lord, he is my feather post, my lord. There cannot be an inter-se transfer between two differently.
Now,
Differently-
one thing, who is there in SEPA?
My lord.
You are supposed to go there from Lemhi.
Yes, my lord.
Now,
That,
who has been transferred from SEPA to elsewhere?
that I am not aware of, my lord.
Okay, whether there's any vacant post there or not? You don't know that.
No, I'm not aware that.
Now, as on today, what is the situation?
As on
You-
today, my lord, I'm on leave, my lord.
You are on leave.
Yes, my lord.
Okay. So perhaps the instruction which we had asked the government advocate to seek was, how can the private respondent be posted into Lemi while you are still there?
Yes, my lord. One point, my lord. That is one of the aspects, my lord. And the other aspects which I'm in my humble submission, my lord,
Hmm.
I'm alleging malafide, my lord, always,
Hmm.
obviously, my lord, because of the manner in which I've been transferred out, my lord. And then,
This was listed for motion?
yes, my lord.
Okay, it's still in the motion stage.
Yes, my lord.
All right.
And my lord, the other aspect which I'm agree with is that, my lord, since even if there is not a clear-cut
Hmm.
transfer order for interstate transfer, my lord, but it seems, my lord, since the private respondent has been transferred into my place, my lord, and he being junior to me, my lord,
Hmm. Yes.
he being junior to me, he being my feather force, my lord, there cannot be an interstate transfer between two differently situated persons, my lord.
Is it not permissible to?
Yes, my
transfer?
lord, I'll place certain judgments, my lord, from our high court, my lord.
Hmm.
My lord, if my lord permits, my lord.
Show me what is there.
2020 for GLT, my lord. $503.
Please repeat. 2000,
2020
2020.
for volume 4, GLT,
GLT,
volume 4,
page
503.
503.
Yes, my lord.
Paragraph.
Paragraph, my lord, it starts from, my lord, 49 to 63, my lord. Here, my lord, in fact,
Paragraph. Tell me the paragraph.
49, my lord.
Hibutama.
Yes, my lord, Hibutama.
Paragraph 49.
Yes. From 49, my lord.
Yes.
May I read it, my lord?
Please read.
From the perusal of the above, order dated so and so referred in herein above, which has been annexed as annexure 8 to the writ petition, it appears that the respondent number 2 was allowed to temporarily look after the charge of superintendent engineering in his own scale of pay as a stopgap arrangement subject to the following terms and conditions. To look after charge is made purely on temporary basis due to exigencies of work in the department. The look after charge shall not confer on him any right to claim continuation and seniority in the post unless his service is regularized by a duly constituted DPC as per the provisions of recruitment rules attached to the post. The look after charge shall be terminated at any time without assigning any reasons and notice. On the above terms and conditions, the respondent number 2, who was at the relevant point of time working as executive engineer, RWD Daporijo division, was posted as SSW in the office of the chief engineer, RWD.
Please pause there for a moment.
Yes, my lord.
Now, what is this SSW?
Senior surveyor of works, right? No.
Is it a post higher than the executive engineer?
Yeah, yes, my lord. Yes, my lord.
SSW is higher than
My lord,
EE.
yes, my lord.
So he was asked to look after the charge of
Yes, my lord.
SSW.
What happens, my lord, when they are in a division, my lord, in the division, they are executive engineers, my lord. But
Okay.
when they are in the planning, they are known as SWs.
SSW.
No, SW, when they are in when
So
they
they
are,
are same.
no, my lord. If in the division, if he said superintendent engineer, he will be SSW, senior surveyor of works. But if he is an executive engineer, he will be SW.
Okay.
So since he was an
SSW is equivalent to superintendent engineer.
my lord, yes,
Okay.
my lord.
So it's a higher post than the EE.
Yes, my lord.
So
But,
read,
he was an executive engineer, but temporarily asked to look after.
understood. Read paragraph 51.
From the above factual narrations, with regard to the status and position of the respondent number 2, it is noticed that the respondent number 2 is an executive engineer in a department who has been allowed to temporarily look after the charge of superintendent engineer in his own scale of pay of executive engineer as a stopgap arrangement in exigencies of the work in the department, and thereafter the respondent number 2, who was working as executive engineer RW Daporijo, was brought to the office of the chief engineer RWD Eastern Zone to look after the charge of SSW in the office of chief engineer RWD Eastern Zone as a stopgap arrangement in exigencies of service. The petitioner thereafter.
Okay, I think it's a long judgment.
Yeah,
Now, where is
yeah.
the relevant portion?
My lord, 54, my lord, and I'll just para 54, my lord.
All right.
Now, therefore, what now therefore requires to be determined is, can the writ petitioner and the respondent number 2, who are not similarly placed officers in the department, vested with the same position and nature, can be transferred inter se? This is what was supposed to be decided, my lord.
Then where is the result?
My lord.
The answer.
No, 57, my lord.
57.
Yes. Para 57. my lord.
No, 57 is reference to some judgment.
Yes, yes. Reference to the earlier judgment, my lord.
Please read 63.
For the reasons and discussion met herein above, I am in respectful agreement with the law laid down by the single judge of this court in WPC number so and so, and therefore of the considered view that the petitioner and the respondent number 2, being not similarly placed officers in the department, there cannot be an inter se transfer between the petitioner and the respondent number 2, and the impugned order dated so and so cannot be legally sustained. Accordingly, the impugned transfer order dated so and so issued by the Secretary RWD Government of Arunachal Pradesh Itanagar by memo number so and so is vitiated by the fundamental error, and the same is hereby set aside and quashed.
Now, what has happened to this case? Any appeal? Was there any appeal?
No, no idea about that, my lord. However, my lord, taking this same situation into the instant case, my lord.
The respondent number 2 in this Kibu Tamang case,
Yes, my lord.
he was EE. He was executive engineer, or what?
Yes, my lord.
But he was working as SSW in the chief engineer RW department,
Yes, yes.
Eastern Zone,
Yes, my lord. On temporary basis, my lord.
on temporary basis.
Yes, my lord.
But his substantive post is EE.
Yes, my lord.
His substantive post is EE, but he was working as SSW.
Yes, my lord. On
Then he-
temporary basis.
Then there was a transfer order to replace the petitioner.
Yes, yes. The petitioner was a officiating superintendent engineer, my lord. He was a regular superintendent.
Regular superintendent.
Yes,
engineer.
my lord.
Okay. So that is your case.
Yes, my lord. As because, my lord, here also, my lord, I'm a DLRSO, my lord.
You're saying there's malafide because MLA intervened. Number 2 is that the junior, your junior has been posted in. In
My
fact,
lord.
he's only an ASSO
Yes, my lord.
Ah.
Yes, yes, my lord.
and he cannot be posted as what is this? DLRSO.
Yes. District,
DLRNSO.
yes. District Lane Revenue Settlement Officer, my lord.
Are the petitioner and the respondent, private respondents, civil servants?
Yes, my lord.
Arunachal Pradesh Civil Service.
Yes,
or
my
what?
lord. Yes, my lord.
Okay. Yes,
My lord,
anything else?
if my lord permits, my lord, on malafide, my lord, I guess.
What is that? Malafide?
1986 for SSC.
Page
131,
131 para.
para 6, my lord. It's a very small judgment, my lord. Oh, sorry.
B.
Para,
Vardharao.
para 5, my lord. Yes, my lord. May I read it, my lord?
Yes.
It is not, no doubt true that if the power of transfer is abused, the exercise of the power is vitiated. But it is one thing to say that an order of transfer which is not made in public interest but for collateral purpose and with oblique motive is vitiated by the abuse of powers. And an altogether different thing to say does such an order per se made in exigencies of service varies by any condition of service, express or implied, to the disadvantage of the concerned government servant. The petitioner who appears in the person placed reliance, as he did in the High Court, on the decision of Mumbai High Court in so and so, so and so. We do not see how the decision can be of any avail to the question of issue. The learn, my lord, I'll just skip this. I'll go to the next page, my lord. It is an accepted principle that in public service transfer is an incidence of service. It is also an implied condition of service, and appointing authority has a wide discretion in the manner. The government is the best judge to decide how to distribute and utilize the service of the employees. However, this power must be exercised honestly, bona fide, and reasonably. It should be exercised in public interest. If the exercise of power is based on extraneous consideration or for achieving an alien purpose or an oblique motive, it would amount to malafide and colorable exercise of power. Frequent transfers without sufficient reasons to justify such transfer cannot but be held as malafide. A transfer is malafide when it is made not for professed purpose, such as a normal cause or in public or administrative interest or in exigencies of the service, but for the purpose, that is to say, accommodate another person for undisclosed reasons. It is the basic principle of rule of law and good administration that even administrative action should be just and fair.
Yes.
Now here it says like, it should not be an order where to accommodate somebody, my lord. And if that has been done, my lord, it amounts to malafide, my lord. Here, my lord, there is a clear case. You or not, my lords, issued by the.
No, this malafide you're referring to in this judgment is
My
only an
lord.
observation.
My lord.
It's only an observation. In fact, the SLP was dismissed.
Yes,
But
yes,
what
my
it
lord.
says that the malafide, if pleaded, has to be considered appropriately. Now, in this case, it also says that if it's against the government policy.
My lord.
Now, in the present case, has it violated the government policy? Government policy, like I already pointed out, is that one can be posted in a place for about 2 years. Thereafter, you have to move. And transfer is an incident of service. You already know that.
Yes, yes, my lord.
Okay. So only malafide which you're trying to imply here is that because the MLA has written some UO and it's solely based on that you have been transferred out. I've understood.
And
Let's
then,
hear the government advocate. All right.
and then my lord is well aware of the fact that in the a government servant should not bring any political influence or any other influence in order to change his service conditions, my lord, whether it's promotion, transfer, pension, or whatever, my lord. And if that be so, and here is a case where he has influence and taken help of the political bosses and the other means, my lord.
Let's hear the government advocate.
My lord.
Mr. Kamdo.
My lord, I've served the instruction.
What is that?
Instruction to the effect that lordship was on that issue where that the petitioner he was still serving that packet case and while the private
No, leave the
respondent
books
number were posted.
Keep it here.
Now
We have not finished.
that part has not been lordship punished to me.
Hmm?
Why while the petitioner was working there at Pake Kesang, why this.
Yes,
Court number
yes.
4
Why?
yeah. That has not been furnished to me also. But his transfer was contemplated. The petitioner's transfer was contemplated since he has already
Completed 2
he
years.
completed his yes tenure
But-
there at Pake
But,
Kesang.
but before that, since you have brought in another person there, that is why you've contemplated transfer.
Yeah,
That
Yeah.
could be the main reason.
yeah, that is the main reason. But regarding this, all this Malay Fide lawsuit, the influence of the local MLA lawsuit, it has been lawsuit held in Muhammad Masood case.
Hmm.
Muhammad Masood versus State of UP, wherein there was a recommendation of the local MLA.
Hmm.
And in this case, in that case, it was held by the apex court that merely recommending someone does not vitiate the transfer order. And it has been held in that judgment that the local MLA, of course, being the public leader of that locality, that area, he can recommend for transfer of any person to his constituency. And that principle is still holds
Okay.
the field lawsuit.
What is that judgment? Do you have the reference?
Lawsuit, Muhammad Masood versus State of UP lawsuit, 2007, I have forgot the volume lawsuit.
No, okay, anyway, what-
I'll
just find out, just find out.
Yeah.
Meantime, what is this instruction which you have just brought?
Instruction is that lawsuit, in the meantime, lawsuit by petitioner has been released. Petitioner has been released by the deputy commissioner to enable him to join at his new place of posting at SEPA. Now, since he has not, since he has been released now lawsuit, and the release order is not impugned in this writ petition lawsuit.
Is it required to improve the release order also?
Lawsuit, that case which I was referring to is 2007, volume 8, page number 150.
Page number
150,
and paragraph,
paragraph 8 laws.
party name?
Party is Muhammad Masood versus State of UP.
Masood, double OD.
Masood, MASHOD, OOD, double OD,
Masood, Mohammed Masood.
versus State of Uttar Pradesh.
You get the book, please get the book.
Yeah.
2007, volume 8, SCC 150.
My lord, yeah, ma'am.
Okay, so this is the first page. What is the second page? These are all the annexures. What are the annexures to this letter? Number 1 is the posting. Number 2 is interest of transfer, so and so, so and so. Then number 3 is
Phase 4 is his release order. And phase 5 onwards, it is transfer guideline.
okay. Then what do you say about this? What that case? What do you call that? Intertransferability of a person who is not of equivalent post.
No,
Hibu Tamas case.
it is not a case that the petitioner is now transferred to non-existing post.
No, no,
That-
we're not
that-
talking about that. I'm talking about the private respondent number 4,
No, sir.
who is basically an SSO.
Yes.
How come he's transferred as DLR and RSO to a senior post?
Lordship, he's.
That has been held to be not permissible as per this Hibu Tama. Have you read Hibu Tama?
No, no, sir.
So it says like that. So petitioner says that this is applicable in my case also, because in that case, the petitioner was superintending engineer. Private respondent was only holding the charge of superintending engineer. And what was that terminology?
SSW.
SSW. SSW is equivalent to superintending engineer.
Yes,
So
yes.
court says that these posts are not intertransferable because they are not equal posts. So similarly, I think there is no dispute to the fact that the post of ASSO and DLRSO are not same.
Not same, Lordship, not
ASSO is a lower post.
below
Hmm.
DLRSO.
So that's
From
why
ASO, he will be promoted to DLRSO.
this is what the learned single judge has said, and whether there is an appeal or whether it has been set aside or not, you cannot say, is it?
Yeah.
Now, here in present case, Lordship, it is not a case that he has been brought somewhere where his designation does not match. He is transferred to STEPA as a DLRSO Lordship. Not that he will be looking after this, the job of ASSO and all.
Petitioner, okay,
Yes.
but what about the respondent number 4?
For Lordship, since there is no,
There is, petitioner was there. Also he was still there. See, recommendation or no recommendation, supposing you say that it was due to the recommendation of the MLA, which is permissible because of this Mohammed Masood's case. Okay. But you should have followed the policy and the proper procedure, the interchanging thing. He comes in, he goes out by the same order.
Lordship,
But he has not gone out. He's still there in Lemi. And additionally to him, you have brought in the respondent number 4. And for about 2 months, they were together there. Petitioner does not know what to do. He has taken leave. And in the meantime, you have posted him out. So this is the situation. Now, what does this Masood's case say? Let us see paragraph number
8 Lordship.
8. In our opinion, allegation of so-and-so is correct. That by itself would not vitiate transfer order. After all, it is a duty of the revenue so-and-so, so-and-so. All right. So we'll issue notice. This has to be stated. All right. Heard, Mr.
Opada, my lord.
O. Pada,
Yes, my lord.
learned counsel for the petitioner, who submits that the petitioner being aggrieved with the order of transfer dated 4/7/2023 within bracket annexure A has filed the instant writ petition. To stop, the learned counsel submits that the petitioner was transferred from Anini, Dibang Valley district to Lemi, Pakekesang district, white order dated 23/2/2021 with immediate effect. And while his transfer and posting at Lemi subsisted, the respondent authorities pursuant to the UO dated 24/4/2023, written by the MLA
MLA come, my lord, state BJP president, my lord.
MLA come state BJP president, Arunachal Pradesh, issued order dated 31/5/2023 transferring and posting respondent number 4, who is an ASSO, to Lemi to look after the charge of DLRSO, which in fact is the post held by the petitioner. To stop. Thereafter, the impugn order dated 4/7/2023 was issued by the respondent authority concerned. Stop. Aggrieved, the petitioner is before this court. Next para, the learned counsel submits that the impugned order dated 4/7/2023 has been issued with malified intention. Because the respondent number 4 has been transferred in to Lemi with the influence of the MLA concerned. Full stop. As such, the impugned order dated 4/7/2023 should be set aside. Stop. In this connection, learned counsel relies upon the case of B. Vardha Rao versus State of Karnataka and others, 1986, 4 SCC 131. Next para, the learned counsel further submits that since the respondent number 4 is junior to the petitioner and holding the lower post of ASSO, he could not have been transferred and posted to Lemi to take up the charge of DLRSO. Stop. He submits that a coordinate bench of this court in Hibutama SE versus State of Arunachal Pradesh and another 2020 for GLT 503 has held that intertransfer of unequal posts is not permissible. Next para, Mr. D. Kamduk, learned State Council, Standing Council,
Land Management.
Land Management Department, submits that as per the instructions given to him, the petitioner, the respondent number 4, who has been released,
Petitioner.
submits that the petition has already been released from Lemi
And respondent number 4 has
to
joined
join
and now
the
functioning.
post at SEPA. And the respondent number 4 is now functioning as DLRSO in charge at Lemi. Next para. Next para. In view of above, issue notice of motion returnable by 4 weeks. Mr. D. Kamluk, learned Standing Council, Land Management, accepts notice on behalf of the respondent number
Number 1 loss.
1. And then number 2. No, you are for the land management. Number 2 is
Yes.
land management.
Both losses. 1 and 2.
1 and 2.
Yes.
Stop. Petitioner to take steps for service of notice upon the respondent numbers 3 and 4 by registered post ADD. Extra copies of the writ petition be furnished to Mr. D. Kamduk within 2 days. Next para, having regard to the projection made by the petitioner and the fact that the respondent number 4 had been posted into Lemi while the petitioner was still holding the post of DLRSO at Lemi. And further, having regard to the fact that the transfer and posting of the respondent number 4 was preceded by a UO note written by the MLA come state president BJP. The impugned order dated 31/5/2023. You have challenged both. Mr. Counsel?
No, my lord.
Which one?
The transfer order, my lord.
Your transfer order.
Yes, my lord.
The impugn order dated 4/7/2023 shall remain stayed. Yes. Much obliged.
My
Much
lord,
obliged.
My lord, I have not joined, my lord, at SEPA. Till now, my lord.
Okay, so I'll state the order.
My lord.
My lord,
Which item?
item 25.
25.
My lord, the order dated 14/6/2023, passed in WPC 493 2019 has not been complied, my lord.
Page number.
Page number, it start from 12 to
Order dated 14/6/2022.
Uh,
Is that it?
yes, yes.
Now, what was the direction?
Direction was, Your Honor, my lord may see paragraph 8, operative portion. Page number 16. After hearing both the parties and upon the perusal of the materials on record, this court is unable to accept the submission made on the behalf of the petitioner. That the direction is liable to be issued for the permanent acquisition of the land.
All right, just a minute. Now, what is this next? There's a writ appeal also.
Yes,
Who filed the appeal?
yes, petitioner has filed an appeal
Who?
before the petitioner.
Petitioner.
Yes, before the division bench. The division has dismissed by upholding this
Who filed the appeal?
petitioner, my lord.
Petitioner.
Petitioner.
What? You
Petitioner-
want the order of this 14/6/2022 of the learned single judge to be complied with? Isn't it?
Yes,
Then why did you file appeal?
because appeal was dismissed and I have no option left here. So therefore, petitioner is want to comply this order passed by this honorable court. Honorable court has observed that there was a
See, direction was to payment of area
yes,
of rent.
yes, yes.
So you're not happy with that? You don't want the rent? Why did you file the appeal?
That's why now I come before this honorable court.
No. Why did you file the appeal in the first place? Writ appeal.
No, my lord, that was not actually my contention when I was filing appeal. My contention, my appeal actually on ground was there was a here an direction also is two part of direction is there. One is for the payment of area and another one is for make an agreement between the Army's authority and the petitioner, and for the future hiring that they were not
All
doing.
right. Please write down. Your name, please.
Odugong.
Heard Mr. O. Dugon, learned counsel for the petitioner. Petitioner or petitioners? Petitioner,
Petitioner, my lord, only petitioner. Sir.
who submits that the order dated 14/6/2022 passed by this court in WPC number 493 of 2019 has not been complied with by the respondents, despite a copy of the same having been furnished to them. How many respondents have you made here? Why so many of them?
My lord, here, my lord. Respondent number 9,
Who
One
is
to nine.
supposed to comply with the direction? Mainly?
Army authority, my lord.
Yes,
Uh,
but who in particular?
Particular,
You have made so many respondents. 1 to
respondent.
1 to 9. Who amongst this is required to be to take the first step?
Commanding officer. Here, local commanding officer, respondent number 7, actually. He is the local,
Whom did you give the copy of the court's order to?
to all the order of the Honorable Court.
Yes. To whom
I
did-
serve all the,
How? By which letter?
my lord may come to the page.
Is it page 30?
Yes, 30.
This is addressed only to the commanding officer.
Yes, yes, because
If it is yes, then why did you make the others a party?
which one? Honorable Court.
Serial number 1 to 9.
They are in writ petition, my lord.
Hmm?
They are in writ petition.
They may be in the writ petition,
And my lord,
but without serving them a copy, how can you file this contempt petition? They will come tomorrow and say that we don't know, we never got a copy of the order. Why have you made us a party?
my lord,
You are required to serve a copy, isn't it?
Yes, yes.
If they're a party to the party respondent to the writ petition. Have you done that?
my lord,
You have not served a copy. You have only addressed one commanding officer. 4 Gorkha Rifles.
my lord, or when order was passed,
Hmm?
their consent was there.
No, that is not
So-
sufficient. Consent or no consent.
Consent was,
Once, listen, Mr. Counsel, once the court passes an order, a judgment, an order or order, whatever, giving certain directions, you are supposed to convey that to that authority. See, this is the order. Please comply with the court's order. And if he or she does not comply, then you come back with the contempt and you plead that person by name. But here is a case, you have only supplied copy to the commanding officer.
my lord, thing is, my lord, it's respondent number 1, 2, they are all in Delhi. So we're unable to
So,
serve our.
so what is, do you have post office here? Postal service? Huh? Do you have that or not?
Yes,
Post
yes,
office is not
yes.
there
Yes, yeah,
in Narlagan.
yes,
By post, you can send registered post, speed post.
yes. I thought you're, my lord, since their counsel was himself was there in.
I'm sorry, that is not the way. Counsel may say yes or no, that person will not know what has happened. Isn't it? This right, since the petitioner has furnished a copy only to the
Respondent number 7.
respondent number 7, comma, let a notice
And-
be,
and-
let notice
And 9, my lord.
9.
Deputy Commissioner.
Respondent number 7 and 9. Let notice be issued only to respondent number 7 and 9 at this stage. Petitioner to take steps for service of notice upon the said respondents by registered post with a review within 3 days. Did I say returnable date? Returnable by 4 weeks, huh? List the matter again after 4 weeks. Mr. Counsel, in the meantime, if you want to, you can send a copy of the judgment to these other respondents.
Yes.
Okay,
yes,
and incorporate that. You see that this is the receipt. I've already sent them.
Yes, yes.
Then we'll think about issuing notice to them. All right.
Obliged.
Next. Yes, Ms. Dange.
Please, Your Lordship. May I pray, Lordship, 26 may be taken up with 28. Though These are two separate writ petitions, but
Okay, you start with 26 first.
yes. Lordship, I retired on 31st of December 2020.
Hmm.
31st of December 2020.
Hmm.
I was released by page number 17. I was before my
From which post?
that's what, Lordship. I was in APCS senior grade, that is ESC. APCS senior grade.
EAC.
Yes, ex-assistant commissioner.
Hmm.
But the post is otherwise known in the recruitment rules as APCS senior grade.
Hmm.
Lordship, after the retirement, the papers were sent to the Director of Audit and Pension by page number 618, Lordship. This is 21st of January 2021, service book and everything. But Lordship, it appears that due to want of a vigilance clearance, they have not given me pension yet, although it's been more than 2 years now. This is in fact the 3rd year. Now, Lordship, all this by page number 23, the particulars it's required for furnishing vigilance report was also sent by the Department of Personnel. This is on 18/12/2022, page 23, Lordship. But till now, nothing has been done. Now, Lordship, it may be, of course, I've been told that it may be because there was a criminal case pending against me, but which was which had culminated into a acquittal, Lordship. That is also has also been annexed, Lordship, page 24. In the month of June to 30 June 2022, I was already acquitted in that case. Now, Lordship, even though they are using the pretext of criminal case, it is as per the CCS, pension rules also, Rule 8, it is not provided that because of a pending case, pension would be denied or withheld, Lordship. This is also
Will issue notice at this stage. Will issue notice, all right?
Yes.
But Ms. N. Duncan, learned counsel for the petitioner, who submits that the petitioner was released on 31/12/2020.
We defect from, Lordship. Order is dated 24/12.
Okay, was released
Yes.
from service. Was released from government service. White order dated 24/12/2020 with effect from 31/12/2020. But however, the petitioner has not been paid any pension till date. Full stop. According to the petitioner, no, cancel that. She submits that the respondent authority concerned has not processed the pension of the petitioner for want of vigilance clearance as required by the Directorate of Audit and Pension. Full stop. She therefore submits that a direction may be issued to the respondent number 3 to issue vigilance clearance to enable the respondent number 2 process the pension payable of the petitioner. Next para. In view of above, issue notice of motion returnable by 4 weeks. Miss R. Basar, learned government advocate, accepts notice on behalf of respondent number
1 to 5, all, Your Worship, all the rest.
1 to 5. Full stop. Notice is therefore complete. Petitioner to serve requisite extra copies of the writ petition to Ms. R. Basar within 2 days. List again after 4 weeks. Now, item 28.
Yes, Lordship.
Is it on similar lines?
Similar, Lordship, I am asking for opening of the seal cover.
Where is that?
This is, Lordship, as per the memorandum, Lordship, page 93, 25/1/2016. Since I've already been, my juniors, my immediate juniors have already been, during the pendency of this, the whole time, my juniors have been promoted to the post of APCS selection grade and admin grade. I have annexed the seniority list also.
Ms. Duncan, this
Yes.
case is not similar to the other one.
Not similar, but the same person, same lordship.
Same person.
Yes, same person, lordship. I have filed a pension case before separately because I'm in dire need of money, lordship. But otherwise, lordship, if they are to give me notional promotion after opening the seal covers on in view of my acquittal, then lordship, it might take time. That is why. Same person, lordship, same date of retirement.
But this will be what? Promotion after your retirement? Notional
Lordship,
promotion.
notional promotion.
From which post to which post?
From APCS senior grade to APCS selection grade. Then,
Senior grade to selection grade.
yes, the hierarchy is like this, lordship. APCS entry, senior grade, then selection grade, then admin grade.
Then why did you write selection and admin in the prayer portion? Please come
Lordship,
to-
both, lordship.
both means?
Both during this whole time, my juniors have been given promotion from the senior grade to selection and then from selection to admin, lordship. During both those DPCs,
Senior grade to selection, selection grade to
admin grade,
admin grade.
2 promotions, lordship. My juniors have been given 2 promotions during this. It took more than
And seal cover was, when was the seal cover procedure adopted?
in the first, lordship, first DPC, lordship. It has not been mentioned here, but obviously I was not given promotion because of that only.
Why you were not given promotion?
Because of this pending criminal case, lordship, in which I've been already acquitted now.
Have you written any representation here?
Yes, lordship.
Just show me that page.
I have made a representation, lordship. Page 95, lordship. I have made a representation relying on the office memorandum dated 25/1/2016, lordship, issued by the Government of India.
Okay, so we'll issue notice then.
Lordship.
Please write down. I heard Ms. N. Dungan, learned counsel for the petitioner, who submits that although the petitioner has been superannuated, white order dated 24/12/2020 with effect from 31/12/2020, the petitioner, by filing this writ petition, prays for opening of seal cover so that she can be promoted from APCS within bracket senior grade to APCS within bracket selection grade with effect from 5/3/2022, and also be further considered for promotion from APCS within bracket selection grade to APCS within bracket admin grade with effect from 9/6/2017. Since both on notional basis, since the juniors, since the petitioner was superseded by his junior. Full stop. The learned counsel submits that the petitioner has also prayed for all the consequential benefits. Full stop. The learned counsel further submits that it was on account of a pending criminal case that seal cover procedure was adopted. But however, the criminal trial has ended in the acquittal of the petitioner, and therefore the petitioner is entitled to be given the aforesaid benefit. Next para, in view of above, issue notice of motion returnable by 4 weeks. Ms. R. Basar, Learned State Counsel, appears and accepts notice on behalf of all the respondents.
Lordship.
Requisite extra copies of the writ petition be furnished to her within 2 days. List the matter again after 4 weeks.
Obliged, Lordship.
My lord, matter may be passed over for a moment. Matter may be passed over for a moment. Leading counsel is coming on the way.
Okay,
My lord, it's 27, 29 and 30 is connected matter. my lord.
sorry?
27, 29 and 30 is connected matter.
Okay.
Much obliged.
May I please, your Lordship?
Item 2.
Lordship, on the amended petition, it seems the Deputy Commissioner has not filed affidavit.
When did you amend?
Lordship, amended
You
petition,
filed recast.
Lordship, in the month of March, Lordship.
Where is your recast?
Lordship? Sorry?
Recast petition.
It
Is,
will-
is
it will-
that not the procedure? You
Yes.
file a writ petition.
Yes.
In the meantime, you want to amend, you
No,
file.
no, amendment was allowed. We had filed the amended and consolidated petition also.
That's what, the
Yes,
recast oblique amended writ petition.
yes.
Is it available here?
It should be there, Lordship.
Amendment.
On that amended and consolidated petition,
When did you file this amended writ petition?
this must have been in the month of
December.
March.
December 21. 21st December 2021. Then counter affidavit filed on 2023 April.
Yes,
So
counter affidavits have been filed in respect of the army authorities and the defense estate officer. But in respect of the Deputy Commissioner, it has not been filed.
there's an
affidavit.
office note here which says that affidavit of opposition filed by the respondent numbers 3, 4, 5, and 6 in amended petition. Have you received the copy?
That is the army authority.
3 to 6.
Yes.
3 to 6.
Hmm. Ye kukar. Ye kukar. 3, 5, 6, and 10 are army authorities. Then. Deny. 11, 12, 13, 14, 15, and 16 have not filed. These are the state authorities.
Yes. Ms.
Your
Pangu,
Lordship,
are you going to file?
we have already filed for respondent number 14, 15, and 16, Your Lordship. In writ petition 97. For Deputy
Amended.
Commissioner. Oh, no, Your Lordship, amendment.
Respondent number? Respondent
So,
number?
Your Lordship, earlier we have filed. Your Lordship, in this, we have not received the amendment copy, Your Lordship. So we need some more time, Your Lordship.
You have not received?
Amendment copy, Your Lordship.
No, we did give the copy. I think might be, they need extra copy. Sorry, Lordship.
We have already filed, Your Lordship, but before the amendment, Your Lordship.
My lord, I'm for respondent number 1, 2, 4, 7, 8, and 9, my lord.
No, have you filed with
Yes,
the counter in the amended writ petition?
Yes, my lord.
You have filed. State has not filed.
Yes, Your Lord, we have not received the amendment copy.
State is which respondent number?
14, 15, and 16, Your Lordship.
11 to 16. 11 to 16.
Ms. Pangu?
11, 14, 15, and 16, Your Lordship.
By our affidavit, my lord, the method is very clear, man. We have already paid the compensation amount, entire compensation amount, along with the additional, my lord, the compensation amount, which they have assessed.
Let them also file that affidavit.
Right.
So you require how many copies of the amended?
Yes, your lordship.
How many copies?
3 copies, your lordship. Or
All
4
right.
copy, your lordship.
4 copies. Ms. Dungan,
Yes,
you will give 4 copies.
Yes, Lordship.
Although the Respondent Union of India has filed counter affidavit to the amended writ petition, Ms. P. Pangu, learned government advocate, submits that she has not received the amended writ petition, and therefore the respondent numbers 11, 14, 15, and 16,
Yes, your lord.
whom she represents, are yet to file their counter affidavit. Next para. In view of above, the petitioners to furnish 4 copies of the amended writ petition to Ms. P. Pangu within 2 days. And the respondent numbers 11, 14, 15, and 16 are granted 3 weeks time to file their counter affidavit. Yes, you are there also.
Lordship, on behalf of the land management, respondent number 12 and 13.
Yes, what do you have to say?
I have no such any instruction as such. I'm just representing here on behalf of him.
What about 12 and 13? Are they necessary, land management?
Yes, Lordship.
So you saw the-
Affidavit may not be necessary, Lordship.
Okay. The land management department, that is respondent numbers 12 and 13, are represented by Mr.
J. Koyu.
J.
Koyu.
Koyu, who appears on behalf of Mr.
Mr. D. Kamduk.
D. Kamdu,
Standing council. and-
Standing Council Land Management. Ms. N. Dungan, learned counsel for the petitioners, submits that the land management department may not be required to file their counter affidavit. And it's mainly between the petitioners and the Respondent Union of India, as well as the other state respondents. Okay.
Oblige.
Item 3.
May your lordship,
Yes.
the petitioner has engaged a Guwahati-based counsel. So we have already filed our additional wakalatnama. So matter may be adjourned and fixed date may be given, or it may be listed after 4 weeks, your lordship.
You are also appearing.
Yes, I'm for the petitioner, your lordship.
You are the new counsel.
Yes, I'm the new counsel and I'm on behalf of PD Nair.
What is your good name?
A Talom.
Miss A. Talom, learned counsel, submits that.
Lordship, since the matter is very urgent and money is going to be again going back.
Just a minute. Miss A. Talom, learned counsel submits that she is led by Mr. U.K. Nair.
PD Nair.
PD Nair in the matter, and they have been recently engaged in the matter.
Yes, your lordship.
She submits that. Therefore, how much time?
4 weeks or any fixed date may be given, your
4 weeks time may be granted
Lordship,
for, just a minute. 4 weeks time may be granted to enable them to prepare the matter. Stop. Okay.
And
What
your
is-
lordship, interim is there, so interim may be
Okay.
continue your.
Lordship,
Yes.
they have been taking repeated after getting interim order. They have been taking repeated.
Okay, now what is the
Adjustment,
interim order? What is the interim order? I have just recorded a submission. I have not granted the prayer as yet. Let us hear you. What is your objection?
NIT not to be finalized without the leave of the court. Lordship.
Okay, where is that order dated?
Order 27/8,
Hmm.
2021, Lordship.
Next para. Mr. Your good name?
I
I Riram, learned counsel, learned standing counsel.
no, Lordship.
Lo-
additional senior government.
Learned additional senior government advocate, on the other hand, submits that this court, by order dated 27/8/2021, has passed an interim order restraining the respondent authorities not to proceed further with the NIT. And therefore, there is urgency in the matter. Full stop. He submits that the petitioners have been taking time on several occasions, and therefore, matter may be taken up expeditiously. So when should we have it come to a consensus? Not 4 weeks. Let it come up
Yes, Your
in the
Lordship.
next week.
Can it be fixed on 19th of September, Your Lordship?
That is almost like taking 4 weeks again.
Yes, then Your Lordship, any short then will be given as per the convenience of the respondent, Your Lordship.
No, see, you tell us, because Mr. Nair is coming from Guwahati.
Yes, Your
Mr.
Lordship.
Riram is here only, so there's no
Yeah.
problem for him.
Okay, Your Lordship.
Next week,
Yes, Your Lordship.
when? Monday,
Uh,
Tuesday, Wednesday?
Can be on 5th of September.
Mr. Riram? Considering the submissions made, let the matter be listed on 5th September 2023 for admission hearing. Interim order passed late to continue till then.
Oh, pleasure.
Please inform Mr. Nair. Yes.
Yes.
Milord, I am extremely sorry. I was in virtual before Chief Justice Court, Milord.
Okay. No, it's okay.
Well, this item 4, I have the instruction from the client to withdraw and challenge the that speaking order, Milord, with a liberty, Milord.
Mr. T.T. Tara, learned counsel for the petitioner, submits that he has instructions to withdraw the writ petition. Full stop. He, however, submits that he may be given liberty to file a fresh writ petition in view of the developments. Full stop. In view of above, the writ petition is dismissed as withdrawn with liberty to file a fresh writ petition if so advised.
Milord,
27.
in where is that earlier writ petition? Purna writ petition.
These are the bunch of cases in
These
which
are bunch of cases, Milord.
you say that they were earlier party,
Yes,
but in fact, they are not a party.
they were not the party, but they
But
are
you're claiming similar benefit.
it's a similar.
So what can be done at this stage?
Only notice may be issued, Milord. And the matter may be tagged along with the other writ petitions.
Which writ petitions?
3 writ petitions were there. Huh? No, there's some writ petitions. Milord, 3 of them were withdrawn.
So see, the thing is that there's already a judgment. There's already a judgment, isn't it?
Or
To consider
Huh.
those.
Yeah, Milord, that's that page 28 to 84. Milord. Where are those previous writ petitions? Number is not there. It's not mentioned.
Okay, we'll issue notice.
Issue notice.
Heard Mr. T.T. Tara, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner seeks for a direction to the respondent authorities to regularize his service in the post of headmaster / vice principal on substantive basis by holding a DPC. Full stop. The learned counsel submits that this court, in fact, provide a common order dated 14/2/2022, wherein WPC number 399 AP of 2019 was one of the case, had directed the respondent authorities to conduct DPC in terms of the recruitment rules of 2012. Full stop. He therefore submits that the petitioner being also similarly situated, he is covered by the said judgment, said order, full stop. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. T. Jama, learned standing counsel, education department, accepts notice on behalf of all the respondents. Full stop. Petitioner to serve requisite extra copy of the writ petition to Mr. T. Jama within 2 days. List the matter again after 4 weeks.
My lord,
Learned-
kindly make this small observation if
Yes.
my lord agree, that the representation to the secretary submitted maybe pending disposal shall not be bound.
Yes. Is it the date? Is the date common for everyone? Or,
Yes, common for everyone. They
Which-
joint representation by these three applicants.
is it page 62 in this case?
That is 59 to 64.
Starting from 59.
Yes. ma'am. Common joint representation has been given. That some others have already been given.
Next para, it is further observed that the joint representation submitted by the petitioner along with others dated 19/8/2021 may be considered and disposed of by the authority concerned, even during the pendency of this writ petition.
Right. But kindly the same order to 29 and 30. my lord.
Similar order in item 29 and 30,
30.
27, 29, 30, similar orders.
My lord, I will provide the read petition number on the same issues. Which was taken up on this Monday. I'll provide the list along with.
Okay,
So it's-
just give one number, that's all.
Yes.
List the matter again after 4 weeks, along with petition so and so.
So it's grateful. my lord.
Please, Your Lordship.
Yes.
There are three petitioners here, Lordship. We are challenging the order of the DPC proceeding as well as the order of the order pursuant to the DPC, Lordship, DPC recommendation, which is at page 82. This is regarding promotion from junior engineer to assistant engineer. Lordship, the RR says 5 years of regular service in the post of junior engineer. We will be covered by the 2006 RR, wherein for promotion to the post of assistant engineer from junior engineer is 5 years in case of degree holders, and we are degree holders, Lordship. So, Lordship, even after being in service for a very, very long time, Lordship, initially where the petitioner number 1 was appointed on 24/11/1997, Lordship, in the post of junior engineer, and the petitioners number 2 and 3 were appointed on 17 December 1997, Lordship. Even after all these years, Lordship, the DPC was finally held on 31st of October 2019, Lordship. And in that DPC, they have said that our promotions are regularized with effect from the date of the DPC, Lordship. Now we are claiming regularization with retrospective effect, Lordship. This will, Lordship, require a considerable amount of time, Lordship, it seems.
There's one,
Yes.
there's one office note here which says that additional affidavit not yet filed by the petitioner. What is this?
Oh,
Are you
Lordship,
required to file additional affidavit?
I was, Lordship, there was some document which I wanted to bring on record, Lordship, to file the additional affidavit.
Are you going
Lordship.
to file?
Lordship, I'll have to take instructions because that document is still with them, Lordship. I mean, with the petitioners, Lordship.
How much time?
Lordship. 2 weeks, Lordship.
All right. Next, right, by filing this writ petition, the petitioners claim that they should be given retrospective promotion from the post of junior engineer to assistant engineer with effect from the date they have completed 5 years.
Lordship. We did effect from the date of vacancy, Lordship. Vacancy.
With effect from the date of vacancy. Full stop. Not full stop. Although they have been promoted to the said post pursuant to the meeting minutes dated 31/10/2019. Within bracket and annexure Roman 7. Next para. The learned counsel for the petitioners, Ms. N. Dungan, submits that she may be given 2 weeks to obtain instructions from our client regarding filing of additional affidavit. Full stop. In view of above, matter stands adjourned for 2 weeks.
Obliged, Lordship.
Yeah, Lordship.
Yes.
Lordship, the leading counsel is having some severe medical issues.
Hmm?
And the leading counsel is having severe medical issues. So let the matter be fixed after
When?
3 weeks,
3 weeks.
Lordship.
Why all the contempt matters have been adjourned today?
So kindly see if it can be disclosed.
I mean,
It can be closed.
is it a coincidence? And I've seen from the morning, all the matters adjourned are mainly contempt matters. Huh?
I think it's coincident only, Lordship. Anyway, Lordship, kindly see if it can be closed, Lordship.
Yes.
Sorry, in this case, I was appearing for the respondents earlier.
Ah.
My name may be struck off along with my associates.
You're no longer appearing.
I'm no longer appearing.
Okay. It is submitted to the bar that the counsel for the petitioner is indisposed, and therefore the matter may be adjourned for 3 weeks. Mr. S. Tapin, learned senior government advocate. You appear for which respondent?
Not a senior government advocate, Lordship. For respondent number one.
One.
Sole respondent.
Appearing for learned counsel, appearing for respondent number 1. You're appearing in your personal capacity.
Yes.
That's what I say. But what is the harm in saying this?
Same.
Learned counsel submits that the contempt petition otherwise can be closed. Why?
It's already complied, Lordship.
Since it has already been complied with.
Complied.
Where is the compliance? Show me.
Kindly see the affidavit filed by them. It's pertaining to Lordship pending bills, Lordship.
Just show me that compliance order.
Lordship, kindly see the
Page 12.
page Lordship 12.
Reason order.
Region order, Lordship.
Now, what was the direction?
Direction was to examine the pending bills of the petitioner, Lordship.
Page.
It's at page 10 of the contempt petition, Lordship.
Yes.
And relevant is, Lordship, at page 12, Lordship.
Operative portion.
Lordship, kindly see the paragraph 5
Five.
onwards, Lordship.
Please read.
That being a petition under so and so, for the present, we are of the view that the interest of justice would be met on a direction to the commandant 5th IRBN B so and so to examine all the supply oblique works order that were issued to the petitioner, and also from records to examine as to which item thereof have been supplied by the petitioner and received by the battalion authority, and also the bills that were submitted by the petitioner against such supply oblique work orders, as well as the bills which were yet to be paid by the battalion. After making the appropriate examination, the commandant 5th IRBN BHQ Pasigat shall pass a region order either on the entitlement or the disentitlement of the petitioner to receive the payment of the bill amount. If the order is in favor of the petitioner that he is entitled to payment of the bills, necessary consequent orders thereof be passed, facilitating the payments of the bills. And if, on the other hand, the commandant is of the view that the petitioner is not entitled for the payment against such bills claimed for, a region order be passed and the petitioner may be communicated, Lordship. And this has to be done within a period of 2 months, Lordship. Then paragraph 7, Lordship.
Now come to page 12 of the counter.
Lordship.
Come to page 12 of the show cause reply.
12, Lordship. Yes, Lordship.
So you're saying that this is the reasoned order passed
Region order, Lordship.
in compliance with the court's order?
Yes, Lordship. In fact, Lordship, this amount was received. Kindly come to page 11, Lordship. It was received on 31st March 2022, Lordship.
1082850.
An order was passed by this Honorable Court, Lordship, on 30 March 2022, Lordship. One day after Lordship passing of the present order by this Honorable Court, Lordship, this was Lordship received by the petitioner, Lordship.
Okay, just come to this page 12 again.
Page 12, Lordship.
Yes, there's a box there, isn't it? That
Lost.
table.
Lost.
First is enterprise. Number 2 is total amount pending.
Yes, Lordship.
Then number 3 is gross, then deduction of TDS.
TDS, Lordship.
So this is the amount.
This is the amount 10 lakhs 28,850 rupees, which the petitioner entitled for, and accordingly it was already released.
Okay, then what is this restricted amount?
Restricted amount, Lordship, for this region, kindly see that on serial number 2, Lordship, clause B, Lordship,
Yes.
2B. The board found, because board was constituted to examine his liabilities, the board found that the bill amount of rupees so and so are above 30% over the ideal rate. He
Alright.
submitted the bills above the 30% to the.
All right, so we'll close the matter.
Lordship, let the matter maybe hard of 3 weeks.
No, no.
So
Why?
Meanwhile, we'll file our regional.
No, why? It cannot go on and on. This is a contempt petition. And I see that the order has been complied with. Court said pass a reasoned order. Reasoned order has been passed.
Lordship.
You're not happy with the reasoned order? Then you file a writ petition again.
That's why,
But
Lordship.
That's why that liberty will always be there. But as far the contempt is concerned, I think there's nothing to look into now. Next para. Considering the submissions made by Mr. S. Tapin, Learned Counsel, the order dated 30/3/2022 passed in WPC number 128 of 2022, which is alleged to have not been complied with, has been perused. Full stop. It is seen that pursuant to the said direction, pursuant to the direction issued, the respondent has passed a reasoned order on 26/5/2022, which is annexed as annexure Roman 4 to the show cause reply filed by the respondent. To stop, a perusal of the same goes to show that the amount found to be entitled to the petitioner is rupees 1082850. Repeat, 1082850. After deducting 2% TDS and also restricting certain amount for the reasons stated in the said order. Stop. It is further seen that the amount found to be entitled by the petitioner has also been received by the petitioner on 31/3/2022. As the money receipt is annexed. In page 11 of the show cause reply. Stop. Next fella. In view of above, it appears that the order of the court has been complied with, and therefore the contempt petition is closed. Next para. It is needless to observe in that if the petitioner is not satisfied with the reasoned order passed on 26/5/2022, he is at liberty to take recourse to such remedy as may be available in law, if so advised. Yes.
Obliged.
Most of them.
Lordship, here I've not received the instructions yet. Some more time may be given.
How much time?
3 weeks, Your Lordship.
As paid for by Ms. R. Basar, Learned Government Advocate, further 3 weeks time is granted for filing counter today.
I'm yet to receive the instruction, madam, in this for respondent number 2, madam. Maybe we are given 3 weeks time, madam.
You want 3 weeks time?
Two, I think, two, he has filed, I think.
For 1 he has filed.
But the
1 and 2 has filed. 1 and 2 has filed?
Yes.
Affidavit, it's on 1 and 2.
Yes, 1 and 2.
They didn't inform me. They didn't inform me. All right then, madam.
Otherwise, my lord.
1 and 2 has filed. There are only 1 and 2 only.
Yes, yes.
Then
It's over only, my lord. Affidavit is over, my lord. So, my lord.
if it's over, only if you say it's over. You want to file a reply or not?
No, not required, my lord. Here, my lord, the issue is, my lord, very limited issue involved, my lord. This, my lord, that whether my lord, the suspension order, my lord, has been, my lord, reviewed in terms of the, my lord, 10 subclause 6 and 7 of the CCS rules, my lord, within the expiry of the period, my lord, by the review committee. This is only the issue involved here.
What is the present status as on today? You are still under suspension?
Yes, my lord. And my lord, law.
And how many, for how many days now?
Now, my lord, will find I was suspended 2020, my lord. 23/3/2020, my lord. Now, I think more than 3 years, my lord. Law says, my lord, within 90 days, if the memorandum of charges.
Charge sheet has been given to you?
So for criminal cases, so for disciplinary proceedings, they have not initiated as on today.
They are not initiated.
Not.
But you are suspended.
Suspended,
How can you do that,
my lord.
Mr. Iram?
And in the affidavit, it was not justified also. They've admitted the part, my lord, they have not done within the.
Either you give charge sheet or you reinstate him. Because with suspension comes benefit of subsistence allowance, which is only not even full the pay, half the pay or something like that. So law is very clear. What is that law?
My lord, this Ajay Kumar Chaudhary and 2010 judgment, my lord.
Mr. Iram, are you ready?
Lordship, need some time.
Okay, you prepare. You speak up. If you want some time to prepare, we'll give you a day or 2 like that. But if the law is clear, you should not keep it pending. The person is on suspension for a long time. It is not one of the best thing to be. You're a government servant, you're suspended for a long time.
I was in the affidavit, my lord, admitted by the respondent, my lord, that not done as required under the law. These are admitted position in the affidavit. So, and law is very clear, my lord.
So we have it on Monday or Tuesday. You prepare?
Yes.
You prepare?
I will have to serve.
It is submitted by the parties that the pleadings are complete and the matter can be listed for admission hearing. To stop the case of the petitioner is that he has been kept under suspension, under prolonged suspension in violation of the relevant CCA rules and also the law laid down by the apex court in Ajay Kumar Chaudhary versus, what is the citation?
My lord, Ajay Kumar Chaudhary, 2015 7 SCC.
2015 7 SCC.
291.
291.
And
Ajay Kumar Chaudhary versus
Union of
India and others. In view of above, list this matter again after a week to enable, okay, not required, after a week, yes.
Okay. Much obliged.
May my lordship. We need some more time to file affidavit.
How much time?
3 weeks.
As paid for by London State Council, further 3 weeks time is granted for filing contract evidence. Yes.
For the respondent number 2, 3, and 4. Lordship.
Yes, what is the submission?
Matter may be taken up after 3 weeks. Since standing counsel power department, Mr. L. Parme is having some personal difficulties.
Similar order, huh? 3 weeks.
Okay.
Yes.
My lord, it was already dealt in great length before yesterday. Challenging the impugn order passed by the deputy commissioner, directing not to renew my land passbook. my lord. From where he has assumed that jurisdiction is a lease to be decided today. And my lord has put certain questions. The first was that what are the procedures for allotment of the land? One, what is the procedure to be followed for cancellation or the renewal of the land passbook, my lord? So therefore, my lord, the aptness would be let the standing counsel for the land management assist the court, or alternatively, my lord, I may be allowed to place the facts in an election.
No, what is that law regarding allotment and cancellation? Is that 2000 Act of
Yes.
2000?
2000 Act.
Let us see the act.
Volume 7, my lord.
Volume 7.
Volume 7. Now the two verification reports are in my favor, my lord. I have not encroached any piece of government land allotted to me. There was no appeal preferred, but the deputy commissioner, in excess of its jurisdiction, came to pass this impugn order on 28/11/2022. Section 12 for a moment, my lord, may kindly be appreciated.
Yes, section 12.
Section 12 is the one. Oh, yes, see.
Allotment of land.
Allotment. Either. Clause 1 says, the deputy commissioner may allot land belonging to the government for agricultural purposes or for construction of dwelling houses in accordance with such rules as may be made in this behalf under this act. 2, the government shall have power, overriding the power of deputy commissioner, to allot any such land for the purpose of an industry or for any purpose of public utility on such condition as may be prescribed. My lord, here I read conjunctively with clause 1 and clause 2, subclause A, the sentence occurring for any purpose of public utility, since the word residential is not described herein.
Yes.
So therefore, the word would mean this, my allotment is done under this.
Hmm.
Now, my lord,
Now, if there's a complaint, then who will examine?
my lord, if there is a complaint, in that even the deputy commissioner complaint is filed before the deputy commissioner.
Hmm.
The deputy commissioner further instructs the district land revenue and settlement officer to carry out the verifications and then to submit report. That is what has been provided right from section 9 to 83 of this act, my lord. And prior to that, my lord, prior to the issuance of the land allotment, thereafter the passbook, which gives a piece of right to any individual that I am the title holder of this particular land on the requirement of law, in that even, my lord, first, a citizen submits a form before the deputy commissioner with no objection certificate from the forest department, no objection certificate from the UD department.
Mr. Tara, I think, yes,
Yeah,
I'll just ask for 5 minutes.
Correct,
to come back.
Yes. Section 12 already. Now, before that, below, I was making a submission, below, how the land allotment are processed in Arunachal, below. The first is, below, there is a form, a standard form prescribed by the government that is available in the office of the District Land Revenue and Settlement Officer. A citizen goes, pay 100 rupees, get the form. Then 1, 2, 3, 4 columns are there, below. There one column is there, below. In one column, it will say date of occupation. Now, in case of government land, below, in case of a government land, in that particular column, below, every individual citizen, they fills up, I have occupied this land from this date. On the basis of this date, then the application submitted before the District Land Revenue and Settlement Officer, it is processed to the Deputy Commissioner. Now the Deputy Commissioner in turn again, my lord, will endorse to the District Land Record and Settlement Officer to carry out a physical verification of the land. Then, my lord, the SK, that Super Kalungo, right? That gentleman who is the in charge of that particular locality will go and visit, make an assessment report. Yes, this land as proposed for getting allotment is free from all encumbrances. Then what happens, my lord? Then the file is processed by the Deputy Commissioner again to the Director Land Record and Director Land Management. And then it goes to the Secretary. Then Secretary puts up before the Cabinet, and the Cabinet decides, and then it comes back. The file rotates back through a channel. Then once the Cabinet decides, it comes back to the Secretary, Minister of Land Management, further endorses to the Secretary, then to the Land Director, then to the Deputy Commissioner, conveying the approval of the government, thereby empowering the Deputy Commissioner to issue the land allotment. Then the second part is, below. The second part is after that formal approval is given, as my lord has seen yesterday, first issued by the Secretary. My lord will see this page for a moment. My lord, page 18, my lord, kindly come in my read petition, my lord.
Yes.
My lord will see that on the top, as approved by the government of Arunachal Pradesh, wide order, number, land management, so and so, dated so and so, so and so, is hereby allotted a plot of land measuring 100 square meters. Then my lord will kindly come to next page. Who is authenticating this order? It is by the Secretary, and it is by the District Land Revenue and Settlement Officer. My lord, therefore, my lord will have the Constitution also for a moment. Article 166, my lord, clause 3. The manner how this order has been authenticated.
No, see this, you said Secretary.
Yes, my lord.
Where?
The Secretary, my lord, SD. SD, my lord. Page 19.
19.
Page
Yes.
19, 19.
No, that is by the Deputy Commissioner.
Yes, my lord. Then
You said Secretary.
yes, the approval of the government is conveyed to the Deputy Commissioner, and on behalf of Deputy Commissioner, it is District Land Revenue and Settlement Officer who has issued this order. So this is, my lord, there is what the requirement under Article 166, Clause 3 of the Constitution. If any order is issued in the name of the governor, my lord, it has to be authenticated by the officer prescribed thereunder, my lord. Unless it is not authenticated by the officer so designated, that is not an order itself. It is rather a piece of paper, my lord.
So anyway, Mr. Tara,
Yes.
regarding, there's no dispute regarding your allotment, isn't it?
Yes.
Is there any dispute?
There is no dispute, my lord.
There's a complaint only
There is a
that
complaint only.
you have encroached upon government land. And the manner in which the matter has been dealt with, that basically is your grievance. Now, question is, how is that complaint to be dealt with? Is there any provision as
The
such?
Deputy Commissioner, my lord, has to refer it to the government for cancellation. He do not have the power, my lord. Neither he is a power under Section 21 of the General Clause Act. He cannot exercise that power to issue power to alter, amend and rescind, my lord.
Now, what about this appellate power?
Appellate power is, my lord, at Section 80 onwards, my lord. Can you come
83.
to 83, my lord?
It starts from 79, appeal and revision.
Yes, yes. My lord, this provision is, my lord, for a moment, I give my interpretation on this, my lord. What happens is, my lord, as I said, once the form is issued by the Deputy Commissioner, then Deputy Commissioner give a notices to the nearby person where the land is situated, per se the neighbors, to giving an opportunity of raising claim and objections, my lord. After 30 days only, my lord, this land allotment paper is processed, subject to the clearance of non-encumbrances from all quarter, my lord. Be it the forest, be it the UD, or be it the urban development, my lord. Or, my lord, be it the individual who are concerned nearby that particular plot of land. So then, my lord, kindly come. That this is dealing with the Section 79 to 80, 81, my lord. And 81, my lord, will come. 81 is governing our field, my lord, here. The government may transfer any case or class of cases arising under this act or any other law for time being in force from any revenue officer to any other revenue officer competent to deal with. Say, for example, my lord, that Nemo Kosek, Judex Kosa, that is there, that phrase is there. No one can be judge of his own cause. Suppose if a DLRSO of that particular area is having interest in that land, so that case will be transferred from there. This is the objective of this particular section. Then 2, my lord, the Deputy Commissioner may transfer any case or class of cases arising under this act or any other law for timing in force for inquiry or for decision from his own file or from the file of the revenue officer to subordinate to him another officer competent to deal with. So therefore, my lord, this particular subsection 2, my lord, here kindly, my lord, will refer to this particular annexure, my lord. Page annexure 4, my lord, page 29 to 31.
Regarding the endorsement by the DC
Correct, my lord.
to the EAC.
To the EAC. And then, my lord, that matter has been adjudicated on merit. Once the matter is adjudicated on the merit, my lord, the estoppel will come. Until or unless if you don't put it challenge under Section 12 of the Public Premises Act, my lord, 2003. Otherwise, the Deputy Commissioner do not have the power under this section.
What is Section 12?
That volume 7, volume 8, Public Premises Eviction of Unauthorized Occupation Act 2003.
What is the page number?
Page 160 in my book, my lord.
160.
160. The objective is there below the definitions. May I help, my lord, turning the pages?
It's okay. Section 12.
Section 12, kindly come. And appeal shall lie from every order of the state officer made in respect of any public premises under section 5 or section 7 or section 8 or section 10 to an appellate officer who shall be the deputy commissioner of the district in which the public premises are situated. My lord. Now, my lord, for a moment, let us pause, my lord, and come to the order passed by the state officer Naharlagar.
39.
Yeah.
Page 39.
Yes. ma'am. Page 39. ma'am. Kindly come to the second last paragraph. ma'am.
Yes.
Peruse land allotment document in connection to the present vacant plot of land in question. And after heard in land to the parties and perusal of the case records, the respondent is possessing same plot of land on the strength of the land allotment wide order dated so and so, and hence this office does not have jurisdiction to cancel the land allotment. Now the finding is there, my lord. He says, I do not have the power to cancel the land because there is no unauthorized occupation of the land, nor there is any illegal structure that I have erected beyond the land allotment allotted to me, my lord.
So this is something extra which is mentioned, isn't it?
Yes.
In fact, complaint was that you are illegally possessing. His job was to find whether it's illegal or not. And he can simply say that you've got a land possession certificate. So it is not an illegal
Then,
possession.
my lord, the next question of law comes in.
No, why should he say now that I have no power to cancel? Not required.
Not required.
This is something extra. His job was to find whether it's illegal or not.
Correct.
Once he finds that there's already a pass issued to you,
Correct, my lord.
so matter ends there.
Matter is there. Therefore, my lord,
Now, another question is that he is the, what do you call, executive magistrate,
come state officer.
but where is that estate officer?
No.
How do you say he's also an estate officer?
My lord, let's kindly come to the order number. Number ESC
Estate.
on the top. Just
So-
below the ESC.
So this will show that
State,
he's also an estate.
EST, yes.
Then this is the first order.
Final order by the ESC on endorsement of the deputy commissioner.
This is the,
This officer has given this
okay.
finding in my.
Was there any other order? No
No,
other.
my
order.
lord.
Only that second complaint came in.
Yes.
Second
That
complaint came.
Second complaint came in, my lord.
And it was then that the
Now-
DC has constituted a 3-member committee.
Correct, my lord. The committee members' finding is also in my favor.
Page
which was
45.
Page 45. Which the learned government council also made a fair submission. The government quarter number so and so at this sector is in peaceful occupation of so and so. During our visit, he was not in the station. However, the committee observed that there was no dismantle of the government quarter in question. The allotment area of 100 square meter was measured, and also it is found that no construction works have been carried out in the allotted area and within the government premises. Clean sheet, my lord.
Mr. Tara, that we have read. Now, after that, what has happened? One more complaint.
Thereafter, my lord, there was a complaint, my lord, filed by the private respondent at page 42 onwards, my lord.
42.
42 onwards.
42.
That is,
No, 41, 42 is dated 7 November.
yes, my lord.
7 November. And
First complaint is on 10/11/2022.
no, after the 7 November,
Huh,
the report is 25th November.
correct, my lord.
So that is
Then
the,
thereafter, my lord, that impugn order came to be passed by the deputy commissioner.
after the report, was there any other complaint again?
No, my lord. After the report, there was no.
So in spite of this report,
Correct, my lord. This
the
impugn order came.
order has been passed.
So, my lord, my respectful submission is that from where the deputy commissioner has drawn the power and jurisdiction, Was it really under a proceedings under section 12 of this Public Premises Act? Or it is in the capacity of a district magistrate? If it is in the case of district magistrate, he ought to have forwarded this complaint to the Director of Land Management, then to the state government for a policy decision to be taken to cancel my land. Therefore, my lord, yesterday I made a very valiant submission. Prima facie, it appears there is a nexus between the complainant and the deputy commissioner. You cannot do this. Any administrative officer per se, my lord, is posted and his salary is paid out of the taxpayer money to serve the people, not to harass the people. It is nothing but the entire proceeding is vitiated with the harassment, my lord. This must go, my lord. In view of the two findings, and let the petitioner, my lord may kindly leave a niche for the petitioner itself to approach the appropriate form. This need to be interfered with all proceedings. It is vitiated. If I have to control myself, my lord, I will say that this is a mala fide exercise of the power.
So this second complaint,
My lord.
filed on 7 November 2022. According to which wherein the 3-member committee was formed. Perhaps according to the deputy commissioner is not completed. So complaint was submitted. I have formed 3-member committee. They have given a report, but there is no finality to it. So now let me take a final decision. That is what perhaps he's contemplating.
But then, my lord, under which jurisdiction? Under which jurisdiction? Whether he has a jurisdiction to do this? You have done the verification and you are not trusting your field officer? My lord will interfere with this order. If there is anything that private respondent, let them have the liberty to approach appropriate forum. The proceeding must go, my lord.
Complainant is respondent number 4. Has anyone appeared?
No, my lord, 4 and 5.
No one appeared.
No, because I am challenging the action of the deputy commissioner.
No, that's okay. But you have included the respondent number 5 also, isn't it?
Yes, my lord.
The complainant.
They are not appearing in even in
Has
the-
notice gone?
Everything, my lord.
Yes, government. Now, Mr. Kamdo, who will submit?
The action of the deputy commissioner, which is impugned on this writ petition. So I will request my friend to advance his submission.
Yes, affidavit is filed by the DC.
Otherwise, lordship, what I can gather from the writ petition
Ah.
and the series of this action taken by the deputy commissioner. There is no point, in fact, issuing the impugned order. I should rather fairly submit that lordship. Because this verification report, it was carried out on the direction of the deputy commissioner. When he has received the verification report, deputy commissioner ought to have acted on the report, on the basis of the report. And what the report says is that there is no encroachment, whatever it is.
Okay.
And more so since the petitioner is having the valid allotment order, which has been issued after proper verification of the ground realities. So there is no point cancelling the allotment order given by the deputy commissioner.
All right. So we'll pass orders then. I think we have heard Mr. Basar already also.
Yes.
Please write down. Heard Mr. T.T. Tara, learned counsel for the petitioner, Mr. D. Kamru, learned counsel for respondent numbers
Respondent number was
1 and 2,
one.
and Ms. R. Basar, learned state counsel, appearing for respondent number
3, Your Lordship.
3. Full stop. No one appears for respondent number 4 and 5, despite notice. Full stop. Having regard to the nature of the controversy involved, the writ petition is taken up for disposal at the admission stage. Full stop. Next para. By filing this writ petition, the petitioner has challenged the order dated 28/11/2022, within bracket annexure 9, passed by the Deputy Commissioner, Itanagar Capital Complex. Directing the petitioner to appear before the court, appear before him on a date fixed with supporting documents relating to the issue. Full stop. The Deputy Commissioner has also directed that till disposal of the case, the land allotment of the respondent, the land allotment, the land allotment of the petitioner should not be renewed. We'll stop. Next para. The facts of the case in brief is that the petitioner was allotted a certain plot of land measuring 100 square meters at D sector, within bracket zonal capital A, Naharlagan, for residential purpose under Naharlagan Township. Wide land allotment order dated 21/6/2019, with certain terms and conditions contained in the said allotment. Full stop. The petitioner has also been given the government land allotment passbook number N/G-15/225/2019. Wherein the details of the allotment and the collection of land revenue has been reflected. Stop. The respondent number 4 on 3/9/2022 filed an FIR before the officer in charge of Naharlagan Police Station alleging that the petitioner have illegally occupied the premises of the government quarter and should accordingly be proceeded with. Under law. What has happened to this FIR? Nothing happened.
Nothing happened.
What is your statement? The next 3 series.
My instruction on that FIR is that, my client was called in the police station, made an inquiry, and on production of the valid land allotment, the case was not registered.
Okay. The police, the officer in charge of Nahalagan police station received the FIR on 5/9/2022 and summoned the petitioner, who then produced the land allotment order that was issued to him. And accordingly, the officer in charge, being satisfied, did not register a case. To stop, the respondent number 4, however, filed a complaint before the Deputy Commissioner, Itanagar Capital Complex, on 9/9/2022, complaining that the petitioner had illegally grabbed the government quarter land and therefore legal action should be taken against him. To stop, the Deputy Commissioner, upon receipt of the complaint, forwarded the same to the Extra Assistant Commissioner, Nahalagan, to examine the matter and take necessary action as per provision of law. Write communication dated 16/9/2022. Next para. Upon receipt of the complaint, the Extra Assistant Commissioner, Nahalagan, issued 2 hearing notices dated 3/10/2022 and 14/10/2022. asking the petitioner to present himself along with relevant documents for hearing. To stop, the petitioner presented himself, not only presented himself for hearing, but also filed written objection against the complaint. Stop. The extra assistant commissioner had also directed the, what do you call that?
SK means
SK,
supervisor kanun go hum log.
SK,
Yes.
within bracket, supervisor, to verify and submit a report to verify and to verify on the spot and submit a verification report. To stop, accordingly, the surveyor concerned on 10/10/2022 submitted his verification report stating that he had physically verified the government quota allotted to the petitioner on the spot and found that there was some extension of the quota by way of erecting a brick wall or extension to the room. And as for the quarter premises, the same was lying vacant and no structures were found within the quarter premises. To stop, the extra assistant commissioner, upon hearing the petitioner and on perusal of the verification report, passed an order dated 2/11/2022. Which was to the effect that upon hearing the complaint, upon hearing the petitioner, upon hearing the parties at length and perusal of the case records, it was found that the petitioner was in possession of the land on the strength of land allotment made in his favor by order number DC/LM-07/2019 dated 21/6/2019. To stop, therefore, the office of the extra assistant commissioner estate officer did not have the jurisdiction to cancel the land allotment. And accordingly, the complaint was disposed of. Next para. The respondent number 4, however, not being satisfied, filed one more complaint before the Deputy Commissioner, Itana Capital Complex, Itana Capital Region on 10/11/2022. Not satisfied with the order passed by the extra assistant commissioner. Mr. Tara, this 10, 11 and 7. So two complaints.
Yes, two complaints.
What did I say last? Not being, next, please read. Filed two complaints, huh? You cancel that sentence from that, the petitioner being, the respondent number 4 not being satisfied, cancel it, write afresh. Next para, the respondent number 4, however, not being satisfied with the order passed by the extra assistant commissioner, filed two more complaints on 7/11/2022 and 10/11/2022 before the Deputy Commissioner, Itanagar Capital Region, /complex. The Deputy Commissioner then issued order dated 18/11/2022, forming a committee comprising of one chairman and 2 other members to verify the status of encroachment alleged to have been made by the petitioner. White order dated 18/11/2022.
My lord, 3 other members.
2,
3.
one is chairman,
One is chairman.
chairman and 2 other members.
3. One is SK, then one is Nirasu, and one is ESC at quarter. Page 45.
45.
Yes.
No, but you come to page 43. This is the order.
Yes, yes, my lord is correct in this, but here report below it is 5 members.
Yes, now SK has joined hands.
Yes.
SK has come in, that's why. Of the constituted committee, then went for spot verification. On 24/11/2022. And after making a verification, submitted its report on 25/11/2022. As per the report, the government quarter concerned was in peaceful occupation of the petitioner, and during their visit to the place, the petitioner was not in station. However, the committee observed that there was no dismantlement of the government quarter in question, and the allotment area measuring 100 square meters did not have any construction works carried out by the LOT. Stop. The committee is also enclosed a copy of a copy, if the a photo taken on the area in question, along with the report. To stop thereafter, the Deputy Commissioner passed the impugn order dated 28/11/2022. To stop aggrieve the petitioners before this court. Next para, Mr. Titi Tara, Learned Counsel, submits that the petitioner has been issued the land allotment order dated 21/6/2019 with the approval of the government of Arunachal Pradesh, after following all the formalities required in this regard. To stop, therefore, the petitioner is in lawful possession of the land allotted to him. To stop, he submits that against the complaints submitted by the respondent number 4 and 5, a verification on the spot was conducted, and the petitioner also was heard. To stop, it was pursuant to such process that the extra assistant commissioner cum estate officer passed the order dated 2/11/2022 with a finding that the petitioner was in possession of the plot of land on the strength of the land allotment order dated 21/6/2019. To stop, therefore, the allegation that the petitioner is a land grabber as contended by the private respondents has no basis and is wholly misconceived. To stop, the Learned Counsel submits that the order dated 2/11/2022 passed by the extra assistant commissioner cum estate officer is a final order, and if the party concerned is aggrieved with such an order, recourse has to be taken as per the procedure prescribed under the Arunachal Pradesh Public Premises open bracket eviction of unauthorized occupants oblique close bracket Act, 2003. And oblique or under the relevant provisions of the Arunachal Pradesh open bracket land settlement and records close bracket Act, 2000. To stop, without taking recourse to the relevant provisions of the two acts, the Deputy Commissioner could not have taken the responsibility on itself to examine the legality or otherwise of the order passed by the extra assistant commissioner cum estate officer. Stop. Not full stop. In view of the fact that on both the occasion and after due verification, it was found that the petitioner was in possession of the land allotted to him, possession of the land in terms of the land allotment order issued to him on 21/6/2019. Full stop. He submits that since the land has been allotted to the petitioner with the approval of the government as required under the law, the deputy commissioner has no power to examine the legality or otherwise, but except to refer the matter to the government if the situation so warrants. To stop. Therefore, the order dated 28/11/2022, according to the learned counsel, is wholly unauthorized and illegal, and the same should be set aside. Next para, Mr. D. Kamduk, learned counsel appearing for respondent numbers 1 and 2, submits that the respondents he represents have not filed counter affidavit, but having regard to the fact that the petitioner was allotted land as per land allotment order dated 21/6/2019, court may consider the same and pass appropriate orders as it deems fit and proper. Next para, Ms. R. Basar, learned state counsel, referring to the affidavit of opposition filed by the respondent number 3, submits that the respondent number 3 had only issued the order dated 28/11/2022, asking the petitioner to be present for hearing him and for perusing the records which he possessed, including the land allotment order. Full stop. Therefore, there is nothing adverse against the petitioner to not cooperate with the steps taken by the deputy commissioner. She therefore submits that the writ petition, being without merit, should be dismissed. Remaining, I will dictate at 2. Okay, we'll assemble again at 2.
September, but I was informed by my senior that he have a fixed matter on 11 of this September. So can the matter be fixed on 11 of this September? And I have to consent from the opposite other side, Your Lordship.
Which item was that?
Item number 3, Your Lordship.
Just note down, huh? Item 3. Instead of 5th September, it will be 11th of September. So whoever's taken that.
I do.
So now let us continue. Next para. I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Stop next para. The complaint against the petitioner, as can be seen, is that he is in occupation of a certain plot of land near the quota allotted to him unauthorizedly, and for which the private respondents had filed an FIR before the Naharlagan police station, before the officer in charge, Naharlagan police station. Stop. However, since the petitioner possesses land allotment order dated 21/6/2019, and on production of the same, the police declined to register a case. Stop. However, the private respondents have again approached the Deputy Commissioner with a complaint, with a similar complaint. On 9/9/2022, and the Deputy Commissioner endorsed the matter to the Extra Assistant Commissioner, come Estate Officer, Naharlagan, on 16/9/2022 to look into the matter and take necessary action as per law. Stop. Upon hearing the petitioner and upon directing the survey concerned to have an on-the-spot verification, the Extra Assistant Commissioner come Estate Officer passed the order dated 2/11/2022 to the effect that the petitioner was in possession of the plot of land in question on the strength of land allotted to him by order number DC/LM-07/2019 dated 21/6/2019. However, not being satisfied with the order, another complaint was initiated by the private respondents before the Deputy Commissioner on 7/11/2022 and 10/11/2022, and pursuant to which the Deputy Commissioner had formed a 3-member committee who then visited the spot on 24/11/2022 and made a report to the effect that the petitioner was in peaceful possession of the quota allotted to him, and that there was no construction found against the allotted area of 100 square meters. Full stop. Despite the same, the Deputy Commissioner has issued the impugned order dated 28/11/2022. Directing the petitioner to be present before him along with the written statement and along with his written statement and supporting documents, and that till the disposal of the complaint, the land allotment of the petitioner should not be renewed. It may be seen that the land allotment order dated 21/6/2019 has been issued by the Deputy Commissioner under the signature of District Land Revenue and Settlement Officer, Itanagar Capital Complex. The allotment order further indicates that the same has the approval of the government of Arunachal Pradesh. White order number LM-294/2019/2163, dated 3/3/2019. The two the two verifications done on account of the complaints submitted by the private respondents and under the direction of the Deputy Commissioner concerned goes to show that the petitioner is in possession of the plot of land in question on the strength of land allotment order. And therefore, it can be plainly seen that the same cannot be termed as an illegal occupation. From the allotment order itself, as already noticed, the same is with the approval of the government of Arunachal Pradesh. Mr. Tara, regarding the cancellation, is there any specific provision anywhere?
Except or otherwise rule 125.
125.
Yes. 2000. No, my lord, there is no. 125 is. Your Honor. One 32 is there. My lord will see this 132 and 133
Of which rules?
2012 rules.
Just pass it on. Rule 132.
And 133. This is how the land are allotted in district and the district or quarter and capital complex.
Please continue. And from the two verification reports, including the order of the extra assistant commissioner come estate officer, there is no such indication that the allotment of the land to the petitioner is doubtful. And in violation of the provisions of any particular law. To stop, since the same has been issued with the approval of the government. To stop. It would be incumbent. It would be only incumbent upon the deputy commissioner to refer the matter to the government for consideration. If such an occasion arises. To stop. However, in the instant case, the deputy commissioner has taken up the matter although no appeal as stipulated either under the Arunachal Pradesh premises, public premises, open bracket, eviction of unauthorized occupants, close bracket, Act, 2003, or the Arunachal Pradesh, open bracket, land settlement and records, close bracket, Act, 2000 has been filed. regarding this non-renewal of the pass, is there any provision anywhere?
No, very well.
The direction of the Deputy Commissioner that till conclusion of the proceeding, the renewal of the land allotment to the petitioner should not be done is also not traceable to any particular provision. Next para, therefore, upon due consideration, this court finds that the impugn order dated 28/11/2022 cannot be sustained in law, and accordingly the same is hereby set aside. Now, needless to state herein that do we make that observation? Required? Not required. Not required. Writ petition accordingly stands disposed of.
Much obliged.
Go. Then one more line. Interim order passed earlier, if any, stands merged with this order. Okay.
May I please, my lord? My lord,
Yes.
here, my lord, the petitioners, my lord, we have 5 in numbers, my lord. They have been in occupation of their respective plot of land, my lord. It's a location is called Lobby. It's Itanagar, my lord. And they have been since 2004. Some of them are from 2007, my lord. They have constructed their respective residential building, RCC buildings are there. They have been staying with the families, my lord, with their family. They are now, my lord. Then what happened, my lord? Page kindly, my lord, turn to page number 21, my lord. Page number 21, my lord. This notice.
No, before that, how many petitioners? 5
5
petitioners.
petitioners.
Where are they residing? On which plot of land?
Lobby colony area name is Lobby, my lord. Itanagar, my lord.
Lobby colony Itanagar.
Yes.
How are they residing here?
Well, they occupied the land in 2000, some of them in 2004, some of them are 2007, my lord. I have given the details here, my lord.
Where is the detail?
My lord will find, I will show. My lord, paragraph 5, my lord, page number 6, my lord. After paragraph 5, it's 4, my lord. After 4, paragraph 5, my lord, page number 6, my lord. So for writ petition.
After 4, it's 2.
My lord, I think because yesterday only matter in the night prepared, my lord. So urgency, my lord. So this petitioner number 1, my lord, occupied into 1994, my lord. It was occupied by his father, my lord. Then, my lord, constructed RCC building. All those photographs I have enclosed here, my lord. Then, my lord, he has this electric connection, water bills, all these things he has been paying, my lord. I have annexed here in this annexure 2 and 3, my lord, in the writ petition, my lord. Then petition number 2 is also from 2004, my lord. Then, my lord, petition number 3, he occupied in 2007, my lord. Then, my lord, petitioner number 4 from 2008, my lord. Then petition number 5, my lord, 2008, my lord. I have, my lord, annexed here, their residential building, my lord. Boundary wall, iron gate, all those, my lord, voter ID card, electric connection, my lord, electric bill, water charges. I have annexed all here, my lord. So they are staying there, my lord.
Show me the bill. Where is the bill?
My lord, kindly turn to page number 29, my lord. This is electric charge bill, my lord.
What is the address?
Address, my lord, Hura Rina is my wife, my lord.
And what is the address? There is no address. You only have a PIN number. So which shows that you are an unauthorized occupant.
My lord, I'll
Prima facie.
Then
You don't have an address.
Lobby, my lord, water charge bill, my lord, will find page number 30, lobby, address written lobby, LOB.
See, any process was done by the respondents. By order by which order? Which
My lord, very
notice?
interesting, my lord. Here basically, my lord, so
No,
far, my
just
lord,
answer. You are aggrieved by which order? Is there an eviction order? You were saying that you'll be evicted tomorrow.
Here's what happened, my lord. First, my lord, issued notice, my lord. No eviction order issued. That's why, my lord, I will show a letter, my lord. How?
So how do you say that you will be evicted tomorrow?
My lord, I will show.
If there is no order?
I will show, my lord, that letter, my lord.
You show me now.
Yes, my lord. I am
Straight away.
Yes, straight away, my lord.
Where?
Page number. Finally turn to, my lord, page number 56, my lord. Annexure 13. 55-6, my lord. My lord, 5-6, my lord. This is the letter, my lord. Passed on, my lord, 22 August 2023. Now, the Deputy Commissioner, he writes letter to the Superintendent of Police. Here, our names are given here, my lord. Saying that, my lord, on 25/8/2023, Deputy Chief Wildlife Warden is going to carry out the eviction. So deploy the, my lord, adequate police force, my lord. That is notified tomorrow, my lord. No notice. Notice given, but
No, please read the letter
My
from the
lord, I will read,
beginning.
my lord.
It's addressed to the SP.
SP, my lord.
Then
The Deputy Chief Wild Warden so and so dated Naharlagan informing that a complaint was submitted to the EAC Itanagar on 3/3 regarding destruction of following 5 departmental governmental buildings at lobby area falls under Itanagar Wildlife Sanctuary Division by illegal occupants. These are the given details, my lord. Name of illegal occupants. These are the writ petitioners, my lord.
all of them.
All
Five.
of them, my lord. 5 of them, my lord. Now, my lord. A joint verification was conducted by the EAC CO Itanagar Deputy Chief Wild so and so and found that the above illegal occupants have completely demolished the building structure mentioned above. Now the encroachers have started construction activities over the encroached land, and hence the Deputy Chief for the Itanagar has proposed to conduct eviction drive on 25/8 so and so, my lord. Therefore, you are requested to provide following police personnel so and so, so and so. Now, my lord.
So this is generated from complaint submitted to EAC Itanagar.
Yes, my lord.
By whom?
By the, my lord, the deputy child, it's, my lord, it seems, my lord, Deputy Chief Wild Warden, he requested he filed the complaint, and thereafter, my lord, he requested this Deputy Commissioner to provide for, my lord, this police personnel. Now the here is, my lord, will find, my lord, the impugn notice, my lord. My lord, may I take to the page number?
Which is the impugn notice?
21, my lord. Annexure 1 series. Very interesting, my lord. This notice was issued, my lord, on 13 July 2023. What is written in this notice is, my lord?
No, page
number 21, my lord.
21.
Start from page number 21 onwards. Now, this is the petition number 1, my lord. Now, this Deputy Chief Wildlife Warden, he writes, whereas wildlife offense reports so and so have been drawn against you for committing offense within Itanagar so and so at lobby for violation of section so and so. Further, you are accused of construction of RCC building so and so without obtaining permission. My lord, means, my lord, I am having the RCC building, I am staying there, my lord, since long time back, my lord. Now, second part, my lord. Therefore, you are hereby given 30 days opportunity to remove whatever structure constructed by at your own cost, failing which necessary action shall be taken as per provision provided under section 34A of the Wildlife Provisions Act. My lord, this notice, my lord, it doesn't contain opportunity of hearing. Straightly concluded that I had illegally constructed their RCC building and is staying there, my lord. No opportunity hearing, nothing, my lord, no prior notice, not allowing me to put my defense, my lord. Now saying,
What is your defense then?
my
Now,
lord, my defense, my lord, that since 2004, my lord, 2007 RCC building constructed. I have,
how,
my lord,
on what basis?
this is a, my lord, occupied land, my lord. This is not only we five are there.
Hmm?
More than 500 residents are there.
Maybe,
People are
but
there,
that is not a justification, na?
my lord, my lord.
There are so many fishes in the sea. Why should
My
you
lord,
catch only one fish? That is not the answer.
I understand. My lord, at
You
least
are
the-
to show that you are in legal occupation of that land.
My lord.
Permission not given, but at least you applied for permission. Anything like that?
My lord, as of now, occupied thereafter, my lord, constructed have been staying, my lord. Now, my lord, what is the requirement? Law requires at least, my lord, that this section 34A itself says, my lord, before initiating any eviction process, my lord, minimum, my lord, first hearing opportunity should be there, my lord. Hearing should be done there, my lord, because it is not mere formality, my lord. Because, my lord, it is only,
Mr. Sona, this area of land, is it under the forest department?
my lord, what?
Why this chief wildlife, deputy chief wildlife warden has issued this?
My lord, he, as per his.
Is it a forest land?
Now
Yes,
he is
sir.
saying that
Very
this
much.
falls under wildlife, Itanagar Wildlife Sanctuary area. He is
Ah.
saying, my lord, I will show that this is his claim. So far, our claim is that, my lord, since 2000, so many long time period we have been staying. We don't know, my lord, on what basis he is making this claim, my lord. At least, my lord, that adjudication has to be there, my lord. This is not something, my lord, all of a sudden I have, I am staying with my family, children, all those things, my lord. My lord, section 34 itself, my lord, says, because section 34 enables the chief warden to initiate the process, my lord.
This
But
is
the-
what Wildlife Protection Act.
My lord, my lord. May I read
What is
section
the, what is the provision? Let's,
provision 34, my lord. It says, my lord, that
have you abstracted here or
I have done, my lord,
where?
paragraph. I quoted, my lord. Paragraph, my lord, page number 13, my lord. Paragraph 14, my lord. Page number 13, my lord. A power to remove encroachment.
No, what about this 29?
29, my lord, not applicable. Why? Because section 29, I have read, my lord. The definition, it says not about encroachment. It says about, my lord, disturbing the wildlife activities, my lord. This encroachment deals with section 34 only, my lord. And section 29 doesn't speak about those encroachment, my lord. Section 29A. Section 29A is not applicable in the present case. At the most, my lord, section 34 is applicable, no doubt, my lord.
But they've quoted 29, isn't it?
Yes, my lord, my lord.
Destruction, etc. in the sanctuary prohibited without permit.
No person shall explore, remove any wildlife, including forest produce, my lord. So,
31A. From where you have come, how you have settled there?
my lord, but my lord, not only me, man. For more than 500 people are there. Not a forest
Oh.
activities are there. My lord,
Don't say not only me, others are also
my lord,
there.
I understand. It's all happened, my lord. It's just
Tell
within
me how you landed there?
occupied, my lord. I've found land, my lord, vacant, my lord. And all the people were already settled there. My lord will see lots of huge buildings are there, my lord. So many commercial buildings. My lord, I have been even issued trading license, my lord, by the government. I have enclosed here also, my lord.
We have a law in our state.
I understand.
We have a law in our state which says that length of settlement in an area does not give you the right to stay in that particular area. Maybe 50 years, 60 years, 80 years,
My lord, I understand.
unless you possess
My lord,
a document.
at this stage, my lord, why I am saying, my lord, that minimum, that due procedural requirement, the due process of law, my lord, that is, my lord, statutory provision itself is there, my lord, section 34. I am, my lord, only on that aspect that adjudication has to be there, at least here,
I understand, Mr. Sonar.
My lord.
So it is only a temporary.
My lord, I understand, my lord.
What right do you have? Okay, today we may say, don't evict them.
My lord.
We'll examine.
My lord. Let them,
But
my lord, let them
Ultimately,
call me.
ultimately, end of the day, what will happen?
My lord, let them, let
Can you prove, can you show that you have the right to remain there?
my lord, what happened, my lord? As of now, so immediately they are trying to, my lord, evict me. Now, what the section 34 saying that proper notice has to be sent to me, my lord. Thereafter, my lord,
No.
I will produce my defense. I will prepare. I will appear before the concerned authority, my lord. Then the authority will decide, my lord, because my lord, authority has to also, my lord, substantiate the claim, my lord. It is not something authority will say, this is my area. My lord, doesn't mean that it has become its area, my lord. So we have to also know, my lord, under what basis the forest department is also claiming and whether this area has been rightly declared as a wildlife or, my lord, so many issues are there. My lord, section 34, my lord, may I read, my lord, 34A. My lord, 34A says, my lord, that provided no such order shall
I've
be
read it,
passed.
I've read it. Unless natural justice, you have to be heard, that's all.
My lord, this is my case here is this, my lord. Of course, I cannot establish my, those things will be decided there, my lord. So thereafter, my lord, if adjudicating authority passes.
See, that's why I was asking you, let us forget all those issues at this moment. You get protection and all that, interim, this, that. But ultimately, end of the day, how will you prove your case?
My lord,
That you have got the right to be there.
I have to see also, my lord, that whether this notification, if they are saying, my lord, that area has been declared as a wildlife, whether law has been followed properly by the government while declaring also, while the people have been consent have been taken, my lord, so many laws are there, my lord. Government also cannot just, my lord, declare like that, my lord. So,
All right, we'll see. Okay, now what do you say?
my lord,
The government, Ms. Ete?
Yes, Lordship, that's notified since 14 June 1988 already, Lordship.
See, you file a response, we'll give them some protection.
No, Lordship, in this
Provide.
case, Lordship, since this is wildlife area, Lordship, Lordship may kindly come to this. Fact is also totally different because Lordship may kindly come to page 56. They were, Lordship, illegally staying in that wildlife government quarter, Lordship. Lordship, kindly see page 56. This one SPT brick wall, Lordship, Forest Protection Office, Flint area, Lordship. Hibatech. This is the petitioner, one of the petitioners.
Yes.
5 petitioners. Second one, Lordship, see type 4 building. They were occupying this illegally. And then when they were asked to vacate this government quarters, they have totally demolished the quarter, and then in that place they have built the present, Lordship, their home, Lordship.
When, okay.
And Lordship, this one, page 56. Type 4 building is Tatung Taga, Lordship. Type 2, Tat Tagi. And type 1, Marbam Takia. And double unit barrack, and this is Hura Eli. Lordship, all these are the 5 petitioners.
Who has demolished these buildings?
They have, Lordship.
They themselves.
They themselves.
Why?
And in
Why?
that place, they have, Lordship, I have taken, after getting this petition copy, I have taken verbal instruction, Lordship. And then, Lordship, may kindly come to page 48.
Why they have demolished?
The government quarters, Lordship.
That's what,
Which is in
why they have demolished it?
Lordship,
Why-
just to take that, occupy that place, Lordship, occupy the area, Lordship. That's why they have, Lordship, page 48. The officer, the deputy wildlife officer has given FIR to the officer in charge on, that is, Lordship, you kindly come to this, page 48. Lordship will see. Here, Lordship, that 2010-22, Lordship. All the numbers are given, Lordship. This is not, and he should be Lordship. All GPS coordinate, Lordship. The sanctuary is maintained by the the department with GPS and all, Lordship. All the number has been given here, Lordship. This is very serious, Lordship. I pray that this honorable court may not, Lordship, intervene in this, interfere in this, Lordship, eviction, Lordship, evicting them. And Lordship, because of this FIR, Lordship, this accused, these petitioners were, Lordship, held also. Lordship, next page 49, Lordship will see. They were tried, order, they were arrested, Lordship, because they have been, Lordship, arrested under PD, public destruction of public property, Lordship. Lordship.
And discipline.
This is very serious, Lordship. There are no other people, these 5 people, Lordship, they have, Lordship, encroached this government quarters, and then they demolished it, and in that place they have, Lordship, built their homes, Lordship. All these, Lordship, stories that they have been, it has been handed over by the father, all these are, Lordship, just they have spun the stories themselves, Lordship. Just in 2-3 years, they have come and they have illegally occupied the quarters. It's very difficult to evict them also once they enter the government quarters also.
So how are you trying to evict them? By following what process?
Lordship, is eviction will be done by the deputy wildlife officer only. In the this one, they are given, they are the estate officer.
No, what is the process?
Process, Lordship, so far the notice, so-called notice, Lordship, we have.
What do you say about this section 34A?
Lordship, I could not got hold of that one.
It says opportunity of hearing should be given to them. That's all.
Lordship, verbally also they have been, since 2020, Lordship, continuously notice has been issued to them. Only the latest one, July, they have annexed here. Earlier also there have been many notices given to them, Lordship. As per my verbal instruction, Lordship.
21 is a notice that you are given 30 days time remove.
Yes.
Straight away.
Before that also we have given notice.
Where?
Lordship, I have verbally, but they have sent to mobile, so.
So that's why, now you see, they have come to this court, they have come to the court, you see. So we have to examine this as per the law. You may be right. They are illegally occupying this place.
And
They should be
Lordship, this
driven
is
out.
Wildlife,
Back
Lordship.
and baggage, they should be thrown out. But then again, some process has to be followed. That much only. So for that's why I'm saying that as of now, don't take coercive steps. And we'll give you liberty to give them show cause or give them a chance of hearing. Then you take action. That's up to you.
Once stay is given, it's very difficult to proceed.
No, we'll make it clear. You also, you have to cooperate so that the matter is settled at the earliest.
Lordship, it's not a simple case of Lordship enforcement only. They have a Lordship, the quarter also have been demolished by them.
So-
are in the PDPP.
So we'll also say that they will not do anything, either construct or demolish. They will not do anything to develop the land or to
Further
destroy the
activities.
land,
Lordship.
further activities
Lordship.
without any order from this court, any permission of they should not do.
Lordship.
Same time, you also will not take coercive steps, but will give you the liberty to follow the necessary process as permissible under law, even during the pendency of this petition. That's up to you. All right, heard Mr. R. Sonar, learned
Yes.
counsel for the petitioners, who submits that the petitioners are aggrieved with the action of the official respondents to evict them from their respective dwelling places. Without following the process of law in this regard. Full stop. He submits that via communication dated 22/8/2023 within bracket annexure 13. The superintendent of police, Capital Complex, Itanagar, has been requested by the deputy commissioner, Capital Itanagar, to provide police personnel to conduct, to enable the, who will do it? Deputy Chief Wildlife. To enable the Deputy Chief Wildlife Warden, Itanagar Wildlife Sanctuary Division,
Yes.
to conduct eviction drive on 25/8/2023. To stop. Mr. R. Sonar, Learned Counsel, submits that the petitioner number 1 has resided in the plot of land at Lobby Colony, Itanagar, since the year 1994. The respondent, the petitioner number 2 since 2004, petition number 3 since 2007, petition number 4 since 2008, and petitioner number 5 since the year 2008 as well. To stop. He submits that the petitioners have constructed their dwelling houses and staying there since then with their families. To stop, however, without any process of law, the respondents are contemplating to evict them by force. To stop, Learned Counsel refers to Section 34A of the Wildlife Protection Act 1972, which provides that an opportunity of hearing should be given to the affected person before the authority concerned passes any order of eviction. To stop, the Learned Counsel submits that the petitioners have been given notice by the respondent authority concerned to remove their structures constructed by them without any opportunity of hearing. Stop. He therefore submits that the impugn action of the respondents requires interference of this court. To stop. In the interim, the Learned Counsel submits that the petitioner may be given protection till disposal of the writ petition. Next para. Miss G. Ete, Learned State Counsel, on the other hand, submits that she has received verbal instructions to the effect that the petitioners are illegal encroachers, and in fact, without any authorization, they had occupied government quarters, and thereafter they have demolished those quarters, and in its place they have constructed their own respective residential houses. To stop, since the petitioners are illegal encroachers and the land falls within the what reserve?
Itanagar Wildlife Sanctuary, my lord.
Sorry?
Itanagar Wildlife Sanctuary.
Itanagar Wildlife Sanctuary, the respondent authorities are within their right to evict the petitioners from their illegal occupation of the land. Stop. In view of above, issue notice of motion returnable by 4 weeks. Ms. G. Ete, Learned Government Advocates, accepts notice on behalf of all the respondents. As such, notice is complete. Petitioners to serve requisite extra copies of the writ petition to Ms. G. Ete within 2 days. Next para, having regard to the provision of section 34 capital A of the Wildlife Protection Act 1972. And also to the fact that no, and also not required. In the interim, it is hereby directed that no coercive steps be taken against the petitioners without leave of this court. To stop. Similarly, the petitioners are also directed not to make any development or changes in the respective plot of land occupied by them without leave of this court. To stop. It is further observed that pendency of this writ petition shall not debar the respondent authorities concerned to initiate necessary steps as may be permissible in law, if so advised.
Much obliged.
Much obliged.
You add one more line, huh? Last line, Akan. Full stop. You know. However, no final order should be passed without leave of this court. This is item number
13.
13.
Yes.
Okay, what is this?
May I also?
Yes.
Lordship, this is the contempt petition. Contempt petition
Yes.
filed in with 24/02/2022 in writ petition number 178 order dated for issuing of NOC.
This we have filed the affidavit. This is the earlier direction of the honorable Malad, this court Malad, it has been complied with. As per
Show me the order. Where's the order?
Malad, it's at page 19.
19.
Yes, it's starting from page 18. And
This is in WPC 178 of 2022.
Yes.
Okay. What is the direction? Operative?
Direction Malad at page 6, page 20, para 6.
Please read.
Malad, upon undertaking such exercise, guideline may be framed if so advised. Decision of secretary as to whether such course in yoga and naturopathy are to be allowed in educational institution in the state of Arunachal Pradesh be taken within a period of 15 days from that of receipt of certified copy of this order. And if decision is in favor of the allowing such course, the guideline be framed by consulting the other authorities within a period of another 30 days thereafter. Now, Malad, regarding this aspect, Malad, this course, Malad, we are accepting, Malad, this is to be allowed. Now, in regarding
No, what is the story? University.
Malad,
Yes.
Which university?
Apex Professional University.
Apex Professional University.
Okay. What are they claiming? They want yoga and naturopathy to be included.
Yes.
Only.
Just a minute. So you have taken this decision?
Yes, Malad.
Where?
Malad, we have
Where is it?
Malad, at page 11, Malad. We have adopted the guideline. Of
11
the
of the.
affidavit of opposition.
Where is that 11?
We adopted the guidelines of the Government of India.
No, who is to take this decision?
Madam Secretary had.
Petitioner was Apex Professional University, correct?
Yes, ma'am.
Yes.
What do they want? They want that yoga and that thing to be
Yes,
produced.
they required NOC, my lord. NOC from no objection certificate.
From?
From the state, my lord.
Yes.
Okay, have you given?
Yes, we have given, my
Where
lord.
is that?
Page 33, my lord.
33.
Yes,
33 of the counter affidavit.
yes, ma'am.
Yes. NOC. To start following course,
Yes.
Bachelor of so-and-so. Yes.
Yogic science.
So this was on 23rd March
Yes, ma'am.
and we still be pending formulation of framing of own guidelines. You say that the guidelines issued by the government of India.
Yes, till we frame this guideline or enactment by the state government, my lord. The government of India guideline will follow.
What is that government of India guideline? Any name?
Yes, my lord, we have annexed at page, next page, my lord, see at page 12, my lord.
No, it's not mentioned in 11 itself.
My lord,
In page 11.
my lord, next page is there, my lord.
No, next page is just state guidelines, but what is the beginning?
Beginning, my lord, we'll see at page 31, my lord. It is forwarded by the Ministry, Government of India to the Secretary of all the state.
31.
Page 31, yes, forwarding letter, my lord.
So this is the forwarding and what begins thereafter is this page 12.
Yes, my lord. Enclosure is page 12. And we adopted.
So you can term it as guidelines issued by the government of India.
Yes, ma'am.
In Ministry of Health and Family Welfare
Yes.
on 4/9/2006.
Yes, ma'am.
Okay. So this is the thing. Now let us go back to the direction given by this court. We are in the interest of then. To examine hospital and allowing course. Of the research course, I regard to refer to upon events we will frame if advice. This is number one. Then so guidelines to be framed within 30 days.
Yes, ma'am.
But you say that guidelines will take time. So in the meantime, whatever guidelines is followed by the ministry,
Yes.
that will follow.
Yes, ma'am. Now, this is as of now, ma'am, this is the government of India guideline we are accepting because this required, my lord, the state government has to make own enactment. Ma'am. Yes, but till now, state government has not passed any enactment.
Understand?
So that's why, my lord.
So why are you aggrieved?
Your Lordship, they have complied with the order dated 24/0/24.
They have complied with so.
Yes, but
so
they
what-
have
what remains?
Lordship, they have issued NOC, but it is written as a provisional, no objection certificate, Your Honor. And in point number 4, it is written as the permission to establish a naturopathy and yoga medical college. And admission of student may be granted initially for a period of 1 year and may be renewed on a yearly basis. Lordship, my only concern is the renewed and the provisional no objection certificate.
My lord, regarding this, my lord, this is generally entire medical college, including dreams, my lord. This is generally this happen at beginning, my lord. Because as per requirement, they may increase the numbers also. That's why, my lord, the provisional is required, my lord. Provisional is given, my lord. Otherwise, once pursuant to this, if they have taken admission, it will be not jeopardized, my lord. It will continue. Only the thing is that for further expansion, for enhancement of the seat, my lord, intact. So this, all the other infrastructure has to be examined by the authority from time to time. That's it.
But Mr. Tagum,
My lord.
duration of the course is how many years?
my lord, is for 5 years. my lord.
5.5 years.
Yes,
My lord.
But you're giving permission only for 1 year
yes, Lord.
and which is renewable.
My lord, this is.
Then who will take the risk?
My lord, this is for their the preliminary starting, my lord. So ultimately, my lord, we are saying that there will no problem, my lord, regarding once they have taken admission, my lord. Only for otherwise, my lord, that is why, my lord, without examining the infrastructure, my lord, they may take the once they take the initial, my lord, the admission, my lord, the next year that has to be again re-examined, my lord. Otherwise, in the order, Malab, there's no NOC, Malab. Otherwise, we are saying that verbally, Malab, there will be no
Be
problem.
taken within a. Or now, regarding introduction of these classes, NOC.
Otherwise, if they.
No, Mr. Tagun, regarding decision whether courses in yoga and naturopathy
Malab.
Yes.
are to be allowed in educational institutions. Where is the decision?
Lordship, in page number 5 in my petition.
Hmm?
In page number 5. Here are 3.
Page number 5 of the affidavit.
Of the WPC.
This is not WPC, it is contempt.
Contempt.
Huh? Page number 5, what is there?
Lordship, may I? That in letter by dated 12/09/2018, Central Council for Research of Yoga and Naturopathy.
No, I have. Where is that page number 5? I have not seen page number 5. That's why. Which page number 5?
Page number 5 of the contempt petition.
No, this is not what I'm looking for. What I'm saying is that direction of the court is that the decision of the secretary as to whether such courses in yoga and naturopathy are to be allowed in education institutions in the state of Arunachal Pradesh be taken within period of 15 days. Where is the decision?
Page number, I'll take instruction this aspect. This.
No, the decision is what? This order regarding NOC.
Yes, madam. No, it's not regarding NOC.
Then
For allowing the process, in the state.
you are to take a decision. You are to take a decision within 15 days.
Yes, Lordship.
Whether courses in yoga and naturopathy are to be allowed in educational institution in the state. So where is that decision?
This page 11.
11 is only guidelines. No, this is 11 is guidelines, but that decision is not there. Na?
I'll take.
That now we have decided that yes, we will all introduce this. And on introduction regarding guidelines, since we don't have our own guidelines and framing will take some time. So we go for the guidelines of the central government. That's a different thing. But you are to take a decision. That part is not there.
That part, I'll take obtain instruction.
Mr. T. Tagum, Learned Counsel for the respondent. How many respondents? Four.
I'm for
You,
2, 3, 4, and 5.
for the respondent numbers 2, 3, 4, and 5 is given 10 days time to obtain instructions as to whether any decision by way of a specific order has been made by the respondent authority concerned to allow educational institutions in the state of Arunachal Pradesh to offer courses in yoga and naturopathy in terms of the direction of this code by order dated 24/8/2022 in WPC number 178 of 2022 at paragraph 6 of the said order. Of the learned counsel shall also obtain instructions as to why permission to establish naturopathy and yoga medical college and admission of students have been granted initially for a period of 1 year to be renewed on yearly basis when the duration of the course of Bachelor of Naturopathy and Yogic Sciences is for 4.5 years.
Roughly 5.5 years.
Sorry, 5.5 years. List the matter again after 10 days.
My lord, 2 weeks time, my lord. I may be given 2 weeks.
All right, 2 weeks time.
That to,
Instead of 10 days.
Secretary.
Yes, just find out what is happening.
My lord,
Because supposing you are a student,
my lord.
you want to go for that course. How many years? 5.5 years. But you come to know that permission is only for 1 year. Then you might think, why should I join or not?
Yes, my lord.
People will not join. Supposing next year permission is not given, 1 year gone like that. So there must be some sort of a, surety that you will complete. If you join, you'll complete. That is the idea behind.
Right.
Yes.
Okay.
Yes. Why is it listed today?
This for order stage.
Order stage. What order has to be passed today?
Lordship, the matter may be hard today and any appropriate order may be passed.
We should hear the matter in order stage or what? Who's for the other side? Yes. Have you filed affidavit?
Yes.
What is the issue regarding?
The issue, your Lordship, I'm challenging the order of no confidence motion.
No
It was-
confidence motion.
Yes, it was passed against me.
Okay.
Right? May I proceed, your Lordship?
In relation to no confidence motion in relation to what?
I am the Gram Chairperson of Kuch Panchayat Yajali.
Panchayat.
Yes.
I think it'll take some time, I think, isn't it? He'll need a detailed hearing. We list it for admission hearing. Is there any urgency?
Actually, not so much, but the pressure from my clients. So
Of course, they will pressure. They should pressure also. But then we don't go by the pressure of clients also.
yes.
It depends on the seniority and the urgency. It is submitted by the parties that pleadings are complete and that the matter may be posted for admission hearing. To stop. In view of above and as straightforward is the matter for admission
After 4 weeks.
When?
Anything.
After 4 weeks.
after 4 weeks. All right. Any interim? No.
No.
All right. Yes.
Oh, your lordship, if it can be hard tomorrow.
Why are you changing your? You said after 4 weeks again. Not tomorrow. If you want it before 4 weeks, we'll grant you.
No,
When do you go?
after 4 weeks then.
Okay.
Because I'll be out of station for some medical grounds. So I was.
Okay.
Oblige, your lordship.
May I, Lordship?
Yes.
Lordship, in this matter, Lordship, I am praying for award of compensation. And
Lordship, I have received instructions. I need time to file affidavit.
How much time?
2 weeks, Your Lordship.
Bomb blast.
yes, Lordship.
Bomb blast by whom?
Actually, Lordship, the bomb blast killed my husband and injured my son by the negligence of concerned authority. Like it's Lordship, this bomb blast was occurred on this firing range, which is situated at this Baliliang, Lohitpur, at Lohitpur. So like
whose firing range is this? By the security forces?
Yeah,
Or what?
yes.
No. Somebody died.
Yes, Lordship.
Who died?
Petitioner's husband.
Petitioner's husband.
Yes.
And who blasted the bomb?
Not blasted, but like
It is a firing range, Your Lordship.
Okay, it's a firing range. Then
Yes, it was but notification was given that no one should be during that period. No one should be. No one should go there in that firing range. Firing ranges of Indian Army, Your Lordship.
okay.
They test their firing and all, Your Lordship.
So they were not. No one was
They are
allowed
not
to go
allowed.
there.
Yes, Your Lordship.
So husband of the petitioner went there.
Husband and her son.
his son.
His son went there.
Yes,
Yes.
Your Lordship.
And then
Because of their negligence, undifused bomb was there, so they got.
okay, they came into contact with undifused bomb.
Yes,
Yes.
yes, that is.
And they
their
died.
allegation.
So in such case, what is the compensation to be awarded? Is there any scheme under the state government? Payment of compensation or ex gratia or anything like that?
There is a law, Maneuvers Field Firing Artillery Practice Act. Under that act, Your Lordship.
Under that act,
Yes,
there is compensation.
there is compensation, Your Lordship.
What is this act? This is Central Act.
It's a central act, Your Lordship.
Central Act.
Yes.
Have you annexed that somewhere?
I have not filed my affidavit, Your Lordship. I'll be filing, Your Lordship.
No, the respondent, the petitioner.
Petitioner, yes.
Where,
They have
where
annexed.
they have you annexed this provision?
It's at page 46, Your Lordship.
46. 46. Maneuvers, Field Firing and Artillery Practice Act. Now, section what? Section 9(4). Subsection 4 of section 9.
Section 5, Your Lordship.
Section 9(4).
9-4, yes.
Power of state government to authorize field firing and artillery practice.
Lordship.
The notice required by section shall be given so. To notice so. No, there is no such compensation here.
Compensation, Lordship, kindly see page,
Five.
5, Your Lordship.
Yes,
Right,
11 section
compensation
5.
for damage caused by.
Right to compensation for damage caused by maneuvers. Where notification issued under section 2 authorizes the execution of military maneuvers, compensation shall be payable from the defense estimates for any damage to person or property or interference with rights or privilege arising from such maneuvers, including expenses reasonably incurred in protecting person, property, rights, and privileges. So section 5 is there.
Yes, Lord, correct, sir.
So why is section 9, subsection 4 was referred to?
So
9 is for power of state government, Your Lordship.
For authorizing
So, yeah,
field firing and
to-
artillery practice.
Yes, Your Lordship.
It is regarding authorization,
Yes,
nothing
Your Lordship.
regarding compensation.
But 4 is notice required by subsection 3 shall be given by the publication in the local official gazette by the state respondent. And it has been complied with, Your Lordship.
Which one?
Notice 9-4, Your Lordship.
9-4 was complied with.
Yes, notice was, sir, was given, Your Lordship.
What is the instruction? Anything for the petitioner?
No, Your Lordship.
What does
They have
it say?
said they have served circular before this fire, before conducting this firing.
So you file your instruction then.
Lordship.
Ms. R. Basar, Lanet State Council submits that she has received the instruction and should be given 2 weeks time to file counter affidavit. To stop in view of above, list again after 2 weeks.
mobilize.
Okay.
My lord, this IA was for the implementing of parties, necessary parties. So last time it was after the particular name should not. So I'm ready to this my lord may delete the name and only the address of the officers, department secretary that will serve the purpose.
You don't want to press your IA?
No, my lord, this IA for implementing of parties, if I'm allowed, so by the older name with a particular name of person, so person may be directed to be avoided, and the secretary other local bodies.
No, what is the claim in the writ petition otherwise?
My lord, the writ petition was about the establishment by partition of the department from urban local bodies, urban town planning and urban local bodies to urban local director, office of director, urban local bodies.
Okay. How many just a minute. How many respondents you have made in the main writ petition?
My lord,
state through GCS. Number 2 is secretary personal training. Number 3 is secretary town planning. And number 4 is director urban body, local bodies.
Yes.
And number 5 is director town planning. So everyone is there.
My lord.
Everyone is already there.
Yes, last occasion it is informed by the government council that the affidavit is filed on behalf of government. And now presently the necessary like secretary air reforms, secretary personnel, and the secretary urban local bodies are required as they are necessary party. If this honorable high court if pass direction, so they may be adequate parties. So, and lastly, the present.
I think firstly we have to consider your IA. With the IA, you want to implead somebody.
Yes, my lord.
Who are those? Show me.
My lord, my claim of impleading is, firstly, it was till number 5, the number 6, Sri Minto Dirchi, who was then the director, urban local bodies, Itana Papampare, was already impleaded by this honorable, allowed to implead, who was then the director. And at number 7, the secretary to the Department of Administrative Reforms, which has been named, and I'm praying for the deletion of the name of
Where?
the secretary, but the secretary, the Department of Administrative Reform may allow to remain, as because they are necessary party, because this is connected with the government's rules, regulations, and
No, Mr. Counsel, don't go like that. See, now you have impleaded 5 persons.
yes, my
I
lord.
mean, five authorities,
Yes, my lord.
5 respondents.
Hmm.
And later on, you impleaded respondent number 6 also,
Yes,
by name. And today, you want to implead some more.
yes, my lord.
Who are those? Show me in your application.
My lord, categorically, I have mentioned in paragraph 2. Of the IA.
What do you mean as regards respondent number 7?
My lord, if
They are not impleaded till now.
not
So how do you name them as respondent number 7 in advance?
A prayed for impleading.
So you are praying for impleadment of some people.
Some more authorities.
Who are they?
Respondent authorities.
Who are they?
Dear my lord, administrative reforms.
Give the name. Tell me the name.
Ajay Gatti, the secretary.
Okay, this
to
is
the
one.
Department of Administrative Reforms. Government
This
of-
is one.
Yes.
Then another one.
Another one is MS Mimum Tang, secretary. Now, then the secretary personnel who has issued the posting of directors to the urban local bodies. And to 2 directors, earlier director Lai Bagra and Minto Dirchi. And the next number is respondent number 9, Arun Garg, the commissioner oblique secretary urban local bodies, who have issued the present director, who have posted present director as director urban local bodies from joint director IT and C. And lastly, as respondent and number 10, people sur under secretary urban local bodies who has signed the posting of director as urban local bodies to the present director urban local bodies. And lastly, which is been added as number 11, is Sri Hanotaka, the present director urban local bodies government of Arunachal Pradesh, to which the petitioner are aggrieved.
So why do you want to implead them?
My lord, there has been bifurcation of one office, new office, where all these are necessary parties, because administrative reforms, without administrative reforms, there cannot be creation of a director, and the new office requires a lot of formalities of the departmental formalities, where administrative reform are the main functioner to the office or to the individual government servant. So, and the other minimum time, the respondent number 8 was the personal secretary, then the personal secretary who has appointed Minto Dichi as a director and Lai Bagra as a director. So who was the appointing authority by that time. That is why the personal secretary is being referred as, if it is if the arguments goes on or reference goes on, the particular authority who has done the process is required if there any direction is required to be passed.
This respondents whom you want to implead, they have taken the steps in their official capacity at the relevant time, isn't it? It is not their own personal, private and personal thing that such decision was taken. So where is the necessity to implead them by name?
No, my lord. Last time, day before yesterday only, I have already said that I have no objection and removing the names. So that is why I'm praying before.
But you are repeating again and again. See, for instance, this Secretary, Department of Administrative Reforms.
Yes, my lord.
Now, number 2 is Secretary, Personal Training. Is it different? Personal and training and administrative reforms, there are 2 secretaries.
Yes, it is
separate.
It's different, my lord.
Okay, if that is true, even then. Administrative reforms.
Yes, my lord.
Then Secretary Horticulture.
Secretary Horticulture, the present Secretary Horticulture, then the Secretary Personnel. So I want to, if my lord allowed, I want to modify, because that is just, I would like to address as a Secretary Personnel Government of Arunachal Pradesh.
So you agree that you want to modify this application?
Yes, my lord.
Then you withdraw and file a separate application.
My lord, if
we will see.
If the only direction can be given.
We cannot modify here in your, you have already written something. How do we modify this? Only the role of the court is to allow or to reject. That's all.
Okay, then my lord, I'll file tomorrow and I'll mention, if my lord permits, then tomorrow matter may be taken up.
Why tomorrow?
I'll file a press.
My lord, my lord,
Yes.
my lord has correctly observed that this person whom the applicant, the petitioner is trying to implead, they have done all those, issued any order on official capacity. Now, many of them are not in this same position now. They are in different, they have already been transferred. Now, I don't understand why the petitioner is trying to implead those persons, whoever has issued any order. Now, regarding my impleadment, Your Honor, my lord, this director, this writ petition was filed even before me being appointed as the director. Now, they have challenged the appointment order of previous director. Now, the issue there is.
You are appearing for which respondent?
Respondent number 4, and now in the IA, respondent, if it is allowed, respondent number 11 in person.
Director.
Incumbent director.
Present director.
What about respondent number 6?
It is
he has already been transferred.
No, are you appearing for him also?
No.
6 is by name, you see.
Yes.
Some order was passed allowing him to be treated as respondent number 6. Minto Dirchi.
Minto Dirchi, my lord.
Minto Dirchi.
Then
respondent number 6, already pleaded by name.
Yes.
You're not appearing.
No. At that point of time, I was not engaged.
I see.
My lord, as per my opinion.
Give me that IA.
My lord, as
26,
per my,
IA 26. Let us see how it was implemented.
My lord, the present director keeps on going and coming. Director, particular director who comes upon whom the petitioner is agreed, that by name, that is, I think that can be.
Yes, if this writ petition allows, then it will have an effect on the director also. But then director does not appoint himself. He is being appointed by somebody whom the government, and the government is already party in this writ petition, my lord. Even if petitioner challenges the appointment of the director, the particular appointment, then that was not done on my personal capacity. I was being appointed by the competent authority, the government. And the action of the government is already impugned in this writ petition. Then I don't understand what is the necessity of me being implemented as in person.
Okay, Mr. Counsel, you just come to your prayer in the writ petition, page 24.
In the writ petition, my lord.
Yes, writ petition, WPC number 484 of 2022. What is your prayer? Number 1, read.
To establish the present new another department, urban local body under proper policy guidelines and government of the government operations to state the posting of function of directors of the new another department of urban local body till such policy guidelines are being made by the government of government operations by fulfilling the all criteria to allow to retain and function of urban local bodies only to the present director as per the government gazette notification census 18 June 2010.
Okay. So supposing your prayer is to be allowed, do they have any role? All these 7, 8, 9, 10, 11% to give relief to your prayer, to your writ petition? How do they come in? How do they fit in?
Just on the basis of protocol.
On personal capacity, they can they do that thing?
No,
they cannot do it.
That is why the
government means who? All the hierarchical officers are there. Commissioner, secretary, director in the directorate.
In that view,
So that is why
I have already agreed.
If you implead by name, they cannot give you on their own private capacity the relief.
Yes, my lord. Yesterday only I
So
agreed to put this on the
on what basis you're filing this? I don't know.
Yesterday only I have already agreed to delete the names.
If you want to add some more departments or some more other authorities, you do so, but not by name. You will
Yes, my
not get anything by name.
Yes, my lord.
Unless you are pleading that there's malafide on the part of certain officers who has created this problem. Then you have to specifically plead malafide, and to invite action against them, you have to establish the malafide that you plead.
My lord, even
Only then you can do that. Otherwise, simply putting names here and there, it will not help.
Yes, my lord. Day before yesterday only I have already agreed to delete the names by names.
Not delete, you withdraw this or I dismiss it. How do you delete?
So
nobody has been implemented. Where is there to delete? It is whether to allow your application or not. That's all. Either you withdraw it or I dismiss it, whichever way you want.
So, my lord, I'll withdraw the same and I'll file it properly.
What do you want to file? You tell me.
Impleting the
whom do you want to implead?
At least present director is very much necessary because he's a function.
Again, you are back to square one. You are always going by name, ABC. How can you do that? They will come and say that it is not my personal capacity I'm doing. I'm holding the post of director. In my official capacity, I have to function as an official law.
My lord, we have already filed affidavit to the writ petition also. The present commander.
My lord, in that connection, I have not received the affidavit yet. So,
what kind of thing is this? How do you say that you have not received? You represent respondent number?
4.
4.
Yes.
2 has also filed. Who's filed? Who's 2? Mr. Tapin is there? 2. Have you served copy?
Yes.
Why is he complaining that he has not received copy?
Without
Have not yet.
Without serving copy, we cannot file.
If the receipt is there, then that is different case. If I had been received, my name would
Your
be
name
reflected.
is?
M. Nibo, my lord.
Your name is there?
Received
Yes. Receive one copy.
on
But it
behalf
is-
of, or personally me or.
No, it says four.
For M. Nibo.
Oh, no.
For M. Nibo, someone might have received.
You see the signature, catch all of that person who has received.
Because that is very important to me, so I should have not ignored this.
Respondent
I'm waiting for the.
Respondent number 4 has also received and filed.
My lord, regarding implement,
My lord, this is not my, neither this is not my signature. The handwriting is not even mine.
Then do you recognize whose signature it is?
Probably by Mr. Bagra, one who stays in the filing section. It
So-
appears to be his signature, his handwriting. Advocate's clerk. That is why I was wondering that when did they file? Because that is very concerned to me, that affidavit is. By the virtue of that affidavit only, I must proceed ahead.
Anyway, no issue, copy is also.
My lord, then if it is like a party is not personally, the present party is not necessarily required, then the present, at least I may be allowed to file one IA for certain amendments, because the present director has again came, and that has also to be reflected, because 2 directors has been already reflected and 1 director has not reflected in the writ petition 484. So if in the form of IA, certain amendment is allowed. So at least I can brought before the court that records of appointments.
No, whom do you want to implead?
Director.
By name?
By name or amendments.
Why by name? All right, anyway, you file it, will be considered at the appropriate time. On the prayer of the learned counsel for the petitioner, applicant stroke writ petitioner, the IA stands disposed of as withdrawn. To stop liberty is granted to file a fresh if so advised. Then in the main writ petition, you write, although the respondent numbers 2 and 4 have filed their affidavit in a position, the learned counsel for the petitioner submits that he has not received a copy of the same. To stop. On checking the records, it is seen that a copy of the affidavit in opposition has been received on behalf of the learned counsel for the petitioner on 15/6/2023. Counter affidavit, you put S, counter affidavits. To stop. However, as the learned counsel, Mr. M. Nibo, submits that he has not received the same, the Mr. S. Tapin and Mr.
Omo.
T. Omo shall give a copy each of the affidavit they filed.
My lord, my small prayer in that case, if I'm not necessarily not required to implead. So regarding the present director, if I'm through the form in the form of IA, if I'm allowed to amend some paragraphs, because
yes, I've given you the liberty to file a fresh IA if so advised. If your IA is reasonable and to the requirement of the writ petition, definitely court will allow.
Yes, my lord.
But
Amendment
if you bring all kinds of names to implead them, there's no necessary.
Yes, not
You'll
necessary.
be dismissed.
Yes. So,
you
certain amendment is required in this, in connection with the present director.
No, for
That
that,
is, that record is not
for that,
reflected here.
this court need not give you permission at this stage. You may file an application and I'll ask you, what is this application? You will say that this is for permission to amend.
Yes, my lord.
And how you want to amend, then you will say, this is how I want to amend. Court may say yes, court may say no. Time will tell. All right.
Yes, my lord.
Next case. This was item 16. 32, sorry.
Wait, Lord, this is pertaining to land matter, my lord.
Mr. Son,
My lord.
might take some time. We'll give you a date.
All right, my lord.
When?
After
Next
vacation,
week?
after puja vacation, man.
What?
September. She's doing that, it should be fixed on past October.
We have no objection.
Okay, as prayed for by the parties, list the matter. On when? 6th of September? Wednesday.
On 6th, Lordship, I have a difficulty in this, 6th September.
Seventh? 7th of September for hearing. Yes.
And next, my lord, next item, my lord, the last item, that is 28.
Which
Yeah.
item? Which item?
Supplementary hearing.
Supplementary.
Yeah,
Item number?
34.
This is 34, isn't it?
21, 22, 23.
Okay. 21 to 23. And this one?
This may also be fixed on the same date.
This is 34. What about 24? Okay, 34 also.
Same
Date, huh?
Same date.
7th of,
My lord, item number 34, my lord, we have objection, my lord. Because we are here since morning for argument, my lord. And now it is a fixed matter. It was fixed yesterday, my lord, with the consent of all. We had no other matter. Since morning, we are staying here up to argue. This morning also, I have a request, confirm this senior, whether he will conduct the hearing. He said, yes, you wait. That's why we are waiting painfully here. And now he is suddenly taking adjournment again. Let's do it anyway, my lord. We are ready for argument.
no,
Please,
he's not taking adjournment.
Yes.
I had said that
Yes,
it'll take some time.
some difficulties.
Court has some difficulties
Okay,
to
okay, my lord.
continue.
My lord, not on 7.
But
in
if
the
you want a
case-
different date, it's up to you.
Yes. My lord, can it be on
Day notice.
14th, Lordship?
Huh?
14th of September.
14th.
Yes.
Okay, ma'am. No problem.
Okay, 34 will be on 14th of September. Then that leaves to item 24, is it?
May I please, your lordship?
Hmm.
In this matter, since the respondents
Hmm.
had filed an affidavit to the effect that they are going to acquire the land, this honorable court had asked for instructions on that.
What is the instruction?
My lord, my instruction is very clear, my lord. Ministry has already sanctioned, my lord. The amount has also been sanctioned, my lord. And we are, my lord, to propose for the, my lord, the acquisition of the land, my lord. So therefore, my lord, with that order, my lord, the matter may be disposed of, my lord. Since this is the, my lord, the approval letter, my lord,
The respondent.
Ministry has accorded, my lord, for acquisition of the land measuring
was, my lord, accorded on 23rd, my lord. 23rd August, my lord, as per this number. I'm directed to convey the sanctions of the
You
president.
give one copy to Ms. Duncan.
I have.
So you have,
one, yes.
you have given me 2 copies. They are same, isn't it?
Same, my lord.
Okay, so what does it say?
My lord, the accord, I'm directed to convey the sanctions of the president for acquisition of 26.50 acres of private land at Minging, Upper Siang district, my lord, Arunachal Pradesh, for establishment of operational logistic infrastructures at the estimated cost of 2,31,64,227. So and so, under the right to fair compensation and transparency in land acquisition, Rehabilitation and Settlement Act 2013, my lord. And my lord, the calculation is given. Serial number 1 is the total, my lord. It is calculated as per the, my lord, the altogether, my lord, land measuring 1 clay 7.
See, on what basis this calculation is made?
My lord,
Who has made this calculation?
my lord, as per the district administration, my lord. This calculation has been given to the, my lord, already forwarded to the ministry, my lord. Accordingly, this has been calculated, my lord. And my lord, I hope so, my lord, the other parties also know the, my lord, denying this amount also.
We are seeing this for the first time. We don't know, but
This is the calculation which is
No,
been
Mr.
done.
See, Mr. Kato, thing is that if you want to acquire,
Yes, ma'am.
there are certain process, isn't it? As per the 2000 Act, even in under the section and under the 1894 Act also, there are certain process.
yes,
First of all, a decision is taken to acquire. Then the government is initiated. The government is moved saying that we want to acquire. The government publishes a notification. Like under the old Act, Section 4,
Right.
Section 6, Section 9.
No, my
These
lord,
are all in stages.
my lord, here,
No,
difficulty.
let me complete.
My lord.
So ultimately, when the government gives the notification, issues the notification under those various sections, then ultimately the district collector conducts the hearing
My lord.
and they go for verification and all that, and it makes the assessment. Ultimately, the award is pronounced.
My lord.
And that award is to be approved by the government.
That is
again.
the correct procedure.
After award is approved, then the approved award is sent to the ministry. Give us the money. Then money is deposited before the collector, then they take out the money. Now, if the landowner is not happy with that, then they also again within the time frame, they file a reference under Section 18. And that the collector will refer it to the LA judge, who is normally is the principal judge or additional district judge. He will have that reference and he may also enhance all that. So this is the process.
Correct.
But here you're showing me that the government has decided, the president has decided to sanction the president is there to acquire the land there in Migi. And this is the amount. So how
Yes,
have you arrived this amount? You are saying that the district authority has calculated it. On what basis?
My lord, basically in this case, my lord.
On the basis of negotiation.
Yes, my lord. On
With
the
the
basis
parties.
of the negotiation, my lord, as per the agreement has already been arrived between the parties, my lord, the amount has also been calculated, my lord. Therefore, this 100 rupees amount is fixed, my lord.
But are you not taking high risk?
My lord.
Are you not taking a risk?
My lord,
If you
this is as per
agree
the-
like that.
As per the communication made to, by the district administration.
Later on, see, supposing they might not do that, they might, supposing if they do it.
My lord.
They said, we have given this amount. It is too less. We are entitled as per the 2013 Act, this much per square feet, market value, 100% solatium. Why they are giving us only this much? Supposing they come back, then what will happen? So that's why I'm telling you, you're taking risk.
Yes, ma'am. And my lord,
But if the chapter is closed, if parties all agree, they said, okay, we will settle with this amount, then it's up to you.
Therefore, my lord, subject to the consent given by the, my lord, the counsel for the petitioner and the petitioner, my lord. My lord, paragraph 2 again, my lord. This has been also reflected, my lord.
No, this is a kind of, I don't know what kind of arrangement is this.
Paragraph 2, same page, my lord. Sanction is hereby accorded for the acquisitions of the said land invoking the urgency clause as provided under section 10 of the 40 of the Act 2015, my lord.
2013 Act?
13, my lord. There is a urgency clause in the, my lord, so as to invoke that, my lord.
Before that, the procedure is, we understand from the provision is, there must be a requisition or acquisition under the rules 3 of the right to fair compensation rules 2015. First, that letter has to go to the district administration, and that will be even taken into consideration by the government, appropriate competent authority. Thereafter, everything will be start. But here, therefore, the time and again, I'm making submission before this honorable court. All the acquisition procedures are not properly followed.
Lordship, before any lengthy discussion, Lordship, there's something I'd like to point out, Lordship. In these kind of cases, Lordship, in our case also, the possession has been under the army since 2010. So in all probability, the petitioners will not object to this calculation because they have no other choice. They have already resigned that they're not going to get anything better.
In our affidavit, everything has been enclosed as because they have given consent, it has to be calculated at the rate of 100 rupees per square meter. Everything has been calculated. Thereafter, matter has been sent to the ministry. Only formalities has to be followed, madam.
So
at this stage.
So what is to be done today then?
Therefore, at this stage, the matter may be disposed of with the directions to the deputy commissioners, who is the acquiring authority, to initiate a process within a period of 1 month.
What process?
If acquisition is at all required to be done, otherwise, if they are giving the consent, even acquisition is not required. Only the amount has to be paid to them.
What direction can be given at this stage?
At this stage, direction may be given to the deputy commissioner as and when the amount is deposited.
Why should we give direction? As and when the amount is deposited, definitely without direction also deputy commissioner will release the amount.
Yes, exactly, Lordship. In such a case, Lordship, why the government should be made party? This is purely a negotiation between mutual understanding.
No, it wasn't a negotiation. Sorry, it wasn't a negotiation.
The agency and the beneficiary.
See, one thing you can do is that in view of this communication, we close the writ petition.
And regarding higher search, we have already deposited.
We close the writ petition.
50.
Lordship,
That's all.
Lordship.
Beyond that, what should we observe? There will be no observation of this court.
Lordship, in similar case, Lordship, by this honorable court, some order was passed saying that if the respondents are ready to acquire the land, then they may do so within certain period. A certain time was given, Lordship.
No, out here, they have already calculated the amount also.
Yes.
So what more can you expect?
And in fact, my lord, I have just in that 30% solution is also provided there and the calculation.
Solution, my lord, it is in serial number 3, my lord. Everything is calculated, my lord. 100% solution, my lord, the interest, everything, my lord, even contingency charges, everything has been included, my lord, as per the calculation given by the my lord, district administration.
So when this is as per the calculation,
My lord,
when are you going to deposit the money? You tell us.
a code has been given, my lord, within a period of 3 weeks, it will be deposited, my lord.
So we'll record your submission and close the matter.
Yes, Lordship.
Within 3 weeks, you'll deposit.
My lord, as in when, my lord, at this stage, my lord, this is the only, my lord, army, it has been sent to the army staff only on, my lord, 23rd August, my lord. 23rd August. Today is the only 24th August, my lord. Yesterday, my lord. It has been sent to the army, my lord. It will take another, my lord, maybe 2 to 3 weeks. So therefore, as in when matter, my lord, amount is deposited, that may be, my lord, dispersed with it. So there's, my lord, what army is taking interest is, my lord, for the, my lord, the security purpose, my lord, the army is, my lord, in the area, my lord.
Ms. Dungan will close the matter. We'll give you liberty also.
My lord.
Lordship, can
keep
it be disposed of like this, since it is more or less a consent order? It would be more or less a consent order. So since
petitioner and the union government. Because here.
if the union government is agreeing to give money, it is the duty of the state government to do the acquisition process, Lordship.
For that, we need to go for this proper adopt proper acquisition process.
No, I think we should not go into any controversy now. Now, union government is saying that we are acquiring it, we are going to pay the money which has already been calculated.
Yes.
Now, the question is that when you will deposit, that's only. And once they deposit, the collector should disburse it. You'll deposit before the collector, or what? To whom?
Deputy Commissioner, my lord.
Of which area?
Upper Siang District.
Upper Siang district.
Okay.
My lord, may I propose one
So
thing,
we
my
close
lord?
that.
The ways in when, my lord, the amount is deposited with the Deputy Commissioner by the Union of India, my lord, directly, straight away, my lord, it will deposit it in the account of the Deputy Commissioner, my lord. And forthwith, if once the, my lord, the amount is deposited, that may be dispersed to, my lord, the.
Obviously,
My
that
lord.
the deputy commissioner cannot keep the money like that, na?
My lord.
If he receives it, he has to do it. Rather, it is you. When will you deposit? That's what I'm asking you.
My lord,
When can you deposit?
my lord, therefore, my lord, my respectful submission is, my lord, only, my lord, without giving any outer limit, my lord. As in when, my lord, the once amount is been deposited. My lord, I am told, as per information, my lord, from the army authorities, my lord, it will be.
That is why
Within
I'll
a period
record-
of 3 weeks, my lord. it
I
will
will
be
record your
deposited.
submission.
Yes, my lord.
No, some limit may be given, otherwise,
No, we're not giving any limit to them.
Yes, ma'am.
They will let them do it.
yes.
As early as possible, my lord, then direction may be given. Army is taking, my lord, the serious, my lord, and the follow-up action, my lord.
Please write down. Parties are represented by the respective councils. Full stop. On 18/8/2023, comma, the following order was passed. Please abstract the entire order, okay? Next para. Today, Mr. M. Kato, learned Deputy Solicitor General of India, submits that no, it's not submits that. Has produced a communication dated 23/8/2023, written by the Deputy Director, within bracket, lands dash Roman 1, comma, Government of India, comma, Ministry of Defense, to the Chief of Army Staff, New Delhi, whereby the sanction of the President for acquisition of 26.50 acres of land at Miging, comma, Upper Siang District, Arunachal Pradesh, for establishment of operational logistics infrastructure at an estimated cost of rupees 2,31,64,227 under the right to fair compensation and transparency in land acquisition, comma, Rehabilitation and Resettlement Act, comma, 2013. Has been given. Full stop. The learned DSGI submits that in view of the sanction conveyed to the Chief of Army Staff by the Ministry of Defense, the amount, according to his instructions, will be deposited tentatively within a period of 1 month before the Deputy Commissioner, Upper Siang District. Next para. Ms. N. Dungan, learned counsel for the petitioners, submits that in view of The sanction accorded. You're accepting it, isn't it? You're accepting it.
Sorry.
The
If
petitioners
lordship-
the petitioners do not wish to press the writ petition.
Not like that, lordship. If some order is passed, like earlier writ petitions, lordship, earlier writ petitions in similar cases, this honorable court had passed orders saying that if to the authorities that if you are going to acquire the land, then do it with as per law within a certain time frame, because they are willing to give the money now, it seems. So because
No. See, now amount has already been quantified,
yes,
2 crores something.
yes,
So this will be deposited.
yes.
What other formalities is required now? Is there any formalities now?
Lordship, at least to whom the money would be given, that sort of, because there are not one but many people here. Some sort of formality, even if,
Then I'll not record your submission. Then you write like this. In view of the above submission, the writ petition stands closed. You will deposit the money, isn't it?
my lord, liberty may be given to me.
The respondent union of India shall deposit the amount as indicated in the communication dated 23/8/2023 before the Deputy Commissioner, Upper Siang District, as expeditiously as possible. To stop the Deputy Commissioner, Upper Siang District, upon receiving the amount, shall disburse the same to the beneficiaries as per the usual formalities without delay.
Some time limit, lordship. Otherwise, I won't be able to come. Last time also, it so happened that after such orders were passed, it took almost 3 years to actually get the money because of.
So then, shall we wait then?
No, lordship, some outer time limit, maybe 1
No,
year also.
I cannot give time. No? I cannot give time.
Well, first of all, amount has to be.
Since they're already agreeing, lordship, not
They're
otherwise,
agreeing,
lordship.
they're agreeing, no doubt.
Yes,
But
since they're
one
agreeing.
cannot give time. How do we give time? I've
Within
already
a
indicated,
reasonable, or else I may be given liberty to approach this court again.
right.
Once the amount is deposited, my lord, that may be disbursed
Yes.
within reasonable time.
Within reasonable time,
This
lordship.
observation can be made also.
If,
No, I've already indicated that.
yes, if they
the-
had not agreed, then I won't say this, lordship.
No, no,
Since everyone is
if the deputy commissioner receives the amount, he will
Yes.
disburse it.
yes,
But the question is, when will you deposit to the deputy commissioner? That I'm not giving you any time frame,
Exactly, my lord.
but I'm recording a submission that within at least 1 month,
My lord.
as per your instructions, it will be deposited.
or lordship, can it be like this? After the amount is deposited before the deputy commissioner, then a certain time limit for him to disburse,
For whom?
for the deputy commissioner to disburse to the petitioners.
That I've said without delay.
Some time, lordship. Otherwise, it'll be like last time it took more than 3 years, lordship.
No, why should the deputy commissioner delay it?
We had to file a contempt petition, lordship.
No, if the deputy commissioner is putting everything on hold, you come to the court, we'll see.
Then, lordship, it may be mentioned that liberty would be given if not done within a
If
reasonable time.
amount is not paid, my lord, always liberty will be with the petitioner.
I'm saying this from experience, lordship.
No, even if that liberty is not there, I think you can always come. There's no such debar.
Of course, lordship.
Any bar that you cannot come.
There cannot be any bar, my lord. That will be subsequent cause of action.
We have already, lordship, waited many years, lordship. They have occupied in 2010, lordship. That is why we are surrendering everything, lordship, not willing to wait for any more years.
Please write down a copy of the communication dated 23/8/2023 produced by Mr. M. Katol on a DSGI shall be kept on record and marked as X for identification. Next para, it is needless to mention herein that if the petitioners, if the respondents do not disburse the compensation to the petitioners in terms of the communication dated 23/8/2023 within a reasonable period of time, the petitioners will be at liberty to approach this court again. I'll not define anything, but reasonable time, you said 1 month, maybe it might take 2 months, we don't know.
Malad, that is
But deposit.
yes, madam.
Madam, I kindly observe that respondent Union of India laws. They now have been trusted the duty for disbursing the amount. Okay.
What?
Only laws
What do you
say
want?
that respondents should disperse the amount, then it includes rest of the respondents also.
Correct, it includes, because deputy commissioner is also one of the respondent. Supposing he doesn't disburse it, then that is why I've included respondents only without saying.
Representing its secretary and director also. If in case the respondent does not deposit the amount, then petitioner will move contempt petition. Again, the contempt petition will be dragged again. Whereas we do not have the role in this.
No,
disbursing the amount.
you have no role.
Age of now.
Land is occupied by whom? Secretary?
No.
Then why are you worried? It's occupied by the army, they will pay. You will come and say that I'm nowhere involved in this case. As simple as that.
There is many contempt petitions pending before this.
Why are you apprehending that? Land is acquired by the army for their use. State government has nothing to do. It is between the army and the landowners. And in between, it's the deputy commissioner who will take the money, receive the money and disburse it to the landowners. That's all. So don't have such kind of apprehension. I don't think nobody will tax you. All right.
Deeply obliged.
Obliged.